Case number 101 of 2022 in the matter between the reopened inquest of the late Abdullah Haron.
Thank you. Good morning, my lord. My name is Advocate Haron today on behalf of the NPA. I am assisted by Advocate D. Julius.
My Lord, I appear on behalf of the Haron family, together with my learned junior. There's no need for a calm. We are instructed by whoever went to provide the public.
I'll just make a few remarks before I allow counsel to address the court. One of the greatest teachings of Mapedi, the nation whose royal family name, Dinokuchara Tulare, I am privileged to carry, is that you should acknowledge what you do not know. In observance of these teachings, I asked a sister who I came to know when I came to the Western Cape, who grew up in the Cape Flats. And I asked her this question: what would you wish me to hear me say in my opening remarks on Monday in the inquest as a Muslim who lost a spiritual leader? That was my question. In appreciation of her words and thoughts, which reflected her lived experience as a Muslim, I want to do justice to her and quote her verbatim. As in my view, her remarks are an expression of ideas, feelings, and expectations, not only of the Haron family, but also the deceased comrades, the Muslim community, but also of the nation and the world. In my view, her remarks also set the tone for what lies ahead of us in the next 2 weeks. And I quote what she had said: "And being my sister, she'll remain my sister, unknown to everyone, for her own safety and sanity, perhaps." And she said, "Life is pretty simple for Muslims. Do right by others and stand firm for justice. Where there are injustices, make amends. Seek to correct the wrongs with good actions that will please our Creator and all of creation. As Muslims, we look for balance. We strive to make things right. There are clear instructions about what is haram and what is halal. The word tawbah in Arabic lies at the heart of all our strivings. It's not really repentance or atonement for sins. It is more about restoring a pristine balance and making oneself right with the world. No excess, no deceit, no hiding. It is literally about being at one with our world. Tawbah in Arabic is derived from the meaning to return. It suggests a coming back to rightness and balance. Prayer is our constant reminder or remembrance of this fact. Tawbah, when we have done wrong or are trying to rebalance social ills, is about a return, therefore plainly to what is right. We have no choice in this matter if we are sincere in our tawbah. And this is what we ask in setting out the wrongs that were done to Imam Haron and his family. Things must be put right. No excess, no deceit, no hiding. Just put truth and justice back into society. This very simple act allows for healing, balance, and regrowth. This is at the heart of all our sincere call for social justice, for environmental justice, and a just world. Acknowledge the wrong, understand it, and put the world to rights. There can be no justice without truth. We must return to truth. Close quote. I have been designated by the Judge President of the Western Cape Division of the High Court, John Mandla Shope JP, which I hereby do, to reopen the inquest into the death of Imam Abdullah Haron. There is reason to believe that his death was due to other than natural causes, and at the request of the Minister of Justice and Correctional Services, Mr. Ronald Ozilamula MP, and the recommendation of the Director of Public Prosecutions, Advocate Shamila Betoy, the inquest is reopened. There was already an inquest held in Cape Town in the District of the Cape from 18 February 1970, and the findings of the court were made in March 1970 under inquest number 50/70. I'll hereinafter be making reference to the 1970 inquest when I refer to that inquest. Section 16.2 of the Inquest Act 1959 provided that, and I quote, findings 2, the judicial officer holding an inquest shall record a finding upon the inquest, A, as to the identity of the deceased person, B, as to the cause or likely cause of death, C, as to the date of death, D, as to whether the death was brought about by any act of omission prima facie involving or amounting to an offense on the part of any person, close quote. The 1970 inquest was before Magistrate J.S.P. King Esquire. The magistrate summoned Professor L. Smith to sit as an assessor, but according to my understanding of the record, Professor Smith did not sit throughout the inquest, but only when what the magistrate called relative evidence was led. The prosecutor was Mr. J.S. Van Gram. Mrs. Haron, who was married to the Imam under Muslim rights, instructed Advocate Cooper SC and Advocate B.M. Keys through the instructing attorneys Mrs. Frank, Bernard and Joffe to act on her behalf and that of her then minor children as persons with a substantial and peculiar interest in the issue of the inquest. The magistrate made the following findings at the conclusion of the 1970 inquest. A, identity of the deceased person, Abdullah Haron, a Malay male, about 45 years of age and a shopkeeper. B, date of death, 27 September 1969. C, cause or likely cause of death, myocardial ischemia, a likely contributing cause being a disturbance of the blood clotting mechanism and blood circulating due in part to trauma superimposed on a severe narrowing of a coronary artery. D, whether the death was brought about by an act of omission involving or amounting to an offense on the part of any person. A substantial part of the said trauma was caused by an accidental fall down a flight of stone stairs. On the available evidence, I'm unable to determine how the balance thereof was caused. That's what the magistrate said. In the light of the reopening, we will continue to dispose of the inquest into the death of the Imam on the existing record as envisaged in Section 17, Capital A, Subsection 2 of the Inquest Act. It seems to me from the reading of the papers that there is no issue as regards the identity of the deceased and the date of death. The issues have been narrowed in my view to two, and I will hear counsel hereon to advise me further. And that is A, the cause or likely cause of death, and B, whether the death was brought about by any act of omission prima facie involving or amounting to an offense on the part of any person. The inquest is open to consider the findings as envisaged in Section 16B and D of the Inquest Act. I have already directed that the inquest shall be held in public as envisaged in Section 10(1) of the Inquest Act. And to that extent, upon application, I have granted the media, both public and private, local and international, audiovisual and print, access to the courtroom. The only limitation to my knowledge is available space as well as compatibility of the electronic devices used to the court recording machines, so that access does not compromise proper record keeping. It is only when it appears to me that it would be in the interests of the safety of any witness, or of good order, or of the administration of justice, that I may direct that the inquest be held behind closed doors, or the presence of any particular person is not desirable, or that the identity of such a person shall not be revealed at all for a period or on conditions. The state, through Advocate Lifa Matobeni, assisted by Advocate Dedri Julius, submitted statements, documents, and information submitted by the police who were investigating the death of the Imam. Advocate Howard Bani, assisted by Advocate Naifa Khan, also submitted through the public prosecutors the relevant documents, statements, and information which they deem necessary for consideration on behalf of the Imam's family. On the basis of the statements, documents, and information submitted, it appeared to me that it is necessary in the interest of justice to call a person or persons who had already given evidence at the inquest, who are still alive, to be subpoenaed to give evidence, to consider the record of the 1970 inquest, and to take any further evidence, including oral evidence. As we begin on day 1 of the 2 weeks, one hopes that we engage in public as it is, in a thorough, proper, full, and fair investigation of the cause or likely cause of death of Imam Abdul Haron, and that we are in truth able to determine whether the death was brought about by any act or omission prima facie involving or amounting to an offense on any part of any person. An impression left by an inductive reading of the existing record is that the 1970 inquest was done under the critical watch, if not direction, of members of the security branch of the South African Police Service. At the risk of sounding to prejudge the issues, it seems opposite that I should make a clarion call that this 2022 inquest is open to anyone who is able to provide relevant and material information to assist the court in determining especially what happened to Imam Abdullah Haron between the dates 28 May 1969 and 20 September 1969. Those are the opening addresses. Are you ready for me, Advocate Matubeni?
Yes, thank you. I am, my lord.
Thank you.
As such, if I may proceed to read now the address to the record, my lord. In the opening of this inquest, I want to address the following main aspect of the matter. I want to set out the framework of the Inquest Act and explain the process that is followed, especially with reference to this matter as it is reopened. In terms of Section 3 of the Inquest Act, whenever there is an unnatural death in the South African court, whenever there is an unnatural death, the South African Service is called to investigate the matter and cause for further investigation to be done. The report of the police in what we call a docket is submitted to the prosecutor in Section 4 of the same Act. In this matter, the docket was submitted to the then Attorney General at the time with a view of an inquest to be held. In terms of Section 6, such an inquest was held and finding was made in terms of Section 16 of the Act. In this matter, the Minister directed in terms of Section 17(a) that the inquest should be reopened by a judge of this court. In terms of Section 8 of the judicial officer holding an inquest is the powers of subpoena and may also be requested by the Director of the Prosecution to cause subpoena of persons to give oral evidence at the said inquest. In terms of Section 9(2) of the Act, the laws governing criminal trials are applicable to the examination, the recording of evidence, and like at an inquest. The usual principle will apply to matters such as privilege, and the evaluation of expert witnesses. In terms of Section 13, the judicial officer has wide discretion to allow documents and statements that are under oath or affirmation, and also statements that are under oath or affirmation. The all-important sections in the Act is Section 16, Section 2, and Section 17, Chapter A, 3B. In terms of the above section, this court will be called at the end of the inquiry of the inquest, be required to make 4 findings: the identity of the deceased, the date of the death, the cause of death, whether the death was brought about by any act or omission prima facie amounting to an offense on the part of any person. For purposes of this reopened inquest, we submit the first 2 findings are not contentious. It is common ground that the deceased was correctly identified. It must be noted that the deceased was declared, was certified dead in detention. The cause of death will be by the cause of death will be determined by the court after hearing the evidence of the state pathologist, Dr. Imam, who revisited the initial post-mortem examination and other medical experts that may be called by interested parties. It is a finding in terms of Section 16.2d that is the most contentious, which is whether there is prima facie evidence of commission of an offense. At this stage, the following must be emphasized. These proceedings are not a criminal trial in which the guilt of a person is proved beyond a reasonable doubt. These proceedings do not constitute a criminal prosecution, which is brought by the state, and in which I seek to prosecute any person. It is an inquiry. These proceedings are also under the commission of inquiry into the broader aspect of their detention in the upper Cape, South Africa. It is an inquiry into an unnatural death of one devoted man to the cause of justice, and whether an offense may have been committed contributing and or leading to his demise. The 2 principal offenses that will be considered are that of murder and culpable homicide. Murder would probably be considered on the basis of dolus eventualis, while culpable homicide may be that the reasonable man would have foresawn the events that took place but neglected to take reasonable steps to forestall them. At the conclusion of this reopened inquest, there are a number of findings that the court may make. If in terms of paragraph D, the court finds that there is a prima facie evidence of the commission of an offense, the matter must be returned to the Director of Prosecutions for further considerations about whether to institute a prosecution. The inquest must also be returned to the Director of Prosecutions if the court is unable to make any of the said trial findings. If the court finds that there is no prima facie evidence of the commission of the offense, there is no reason for the Director of Prosecutions to consider the matter afresh, and the inquest will finally be returned to the magistrate of the district in which the death occurred. In this matter, the statements and documents and information submitted to the court in terms of Section 5.2 are contained in lieu of arch files, which have been prepared by the state and placed before the court. There contain copies of contents of original inquest record with exhibits as well as additional materials. All the information in those files must be considered by the court, and the court will hear the evidence of witnesses whose names appear on the schedule list that has also been put before the court, will be put before the court. The following categories of witnesses will testify. There will be eyewitness who will testify about the time the late Mr. Haron was in detention, what he saw, observed, and on the tragic morning of the 27th of September 1969. There will be inspection in local evidence, photographs taken of the deceased inside the cold cell are filed in a separate file, and we would ask that these files be used strictly so as not to traumatize the family or any other persons any further. There will be much technical evidence led by interested parties in an attempt to establish what caused the death of Mr. Haron. The determination of the cause of his death is fundamental to this inquiry into whether any person has possibly committed an offense. This leads me to quote from the preamble of our South African Constitution, which opens the following lines. We, the people of South Africa, recognize the injustice of our past, honor those who suffered for justice and freedom in our land, respect those who worked to build and develop our country, and believe that South Africa belongs to all who live in it, united in our diversity. Therefore, through our freely elected representative, adopt this Constitution as the supreme law of the Republic, so as to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. Lay the foundations for a democratic, open society in which government is based on the will of the people and every citizen is equally protected by the law. Improve the quality of life of all citizens and free of the potential of each person, and build a united democratic South Africa able to take its rightful place as a sovereign state in the family of nations. May God protect our people, Mutsimo, Fawutsetsa, Africa, Nkosi sikelele Africa. Morena Mulega, Sichaba, Sayesu, God siense Africa. God bless Africa, Kosi Katekisa Africa. Close quote. Our beautiful South Africa envisaged in the above quote is still bleeding the hurt, trauma and devastation of the apartheid South Africa. This year, as we mark the third anniversary of the death of the Imam Haron, we also deal, confront and wish for the truth to finally take its place. To quote from the reopened inquest of to the death of Timon, Justice Monthe stated as follows, I quote, considering the prospectus of the documents submitted thus far, there is no doubt in my mind that during these proceedings, we, as South Africans, are about to enter a law that will rekindle painful memories. That invites us to embark on a journey which will cause all of us to confront the sordid past of our country and history. That door will only be closed once the truth has been revealed. This is the fourth of its kind in the dawn of democratic South Africa, noteworthy to mention the successful overturning of the two reopened inquests into the death of Mr. Timon and Mr. Albert, equally who died in the hands of the brutal security police force supported by the then apartheid government with the introduction of oppressive laws. We will endeavor to show to this court through evidence the horrifying modus operandi of torture and detention in the apartheid South Africa. This became custom, it was rhetoric, in many deaths in detention, as mentioned in the book penned by the late Advocate George Bezos, in the book entry titled No One to Blame. We will submit later that the massive and deliberate fraud was perpetrated by the state machinery in the 1970 inquest. As such, it demands justice to prevail. What we will attempt to show is the inconsistencies, contradiction in the version provided by the security branch, police who were the only witnesses called to testify with the ultimate unaccounted injuries on the late Mr. Haron's body. We seek to give effect to the Audi Paltram rule, its full meaning in embarking as such. It could not have been easy 53 years for the Haron family waiting for this day to come. We are privileged and humbled to be part of the NPA that is now alive to the plight of the South Africans who suffered under the apartheid regime and still have not fully benefited from the sacrifices of their loved ones, and now is willing, able to initiate a process through healing.
Lord, we've prepared written opening address, which if you leave, we'd like to hand out a copy. he had to do justice to the life and death of anti-apartheid activist and religious leader Imam Haron. More than 53 years ago, Imam Haron was detained by the security branch in terms of the notorious Section 6 of the Terrorism Act 83 of 1967. He was interrogated by members of the security branch, the erstwhile South African police, including, I might add, the notorious Speaker van Wyk at Caledon Police Station, and occasionally in his cell at Maitland Police Station, and my lord, possibly other undisclosed places. Lord, we will demonstrate that Haron was subjected to unrelenting brutality during his detention of 123 days. His battered and bruised body was found in a cell at Maitland Police Station on the morning of 27 September 1969. He was 45 years old. The autopsy noted that Haron had 27 bruises over his body as well as a fractured rib. Yet, my lord, the security branch claimed that he was well treated. They denied any assault or abuse and claimed that those injuries were sustained during a fall down a staircase at Caledon Police Station, now known, my lord, as Central Cape Town Police Station. Lord, we intend to demonstrate that this version was manufactured to mask the real causes of those injuries. Back in 1969 and 1970, the Haron family was forced to sit powerless as an intricate web of lies unfolded to protect the security branch members responsible for Haron's death. The Lord, all key officials at the time played their role, either directly in the cover-up or by averting their gaze or feigning ignorance. Aside from the interrogators themselves, these included senior security branch officers, members of the uniform branch, the investigating officers, the district surgeons, the visiting magistrates, and indeed the prosecutor in the first inquest. They all played their part, my lord. They did what was expected of them.
I will hear evidence here on council, but what worried me more specifically was the medical professionals at the time. But we'll get to that.
Indeed, my lord. And we share your deep concern. And we will be
Especially those who were elevated to the position of being district surgeons. In other words,
The medical officer responsible overall for the health and welfare of inhabitants of the district, at that level. But as I say, I'm just thinking loud on your address.
Yes, indeed, my lord. And it is incumbent upon this traditional part to ask those questions. These are concerning questions because we're dealing here with medical professionals who would be holden under the Hippocratic Oath to care for people they were meant to be treating. And my lord, we will be submitting that the doctors in question averted their gaze. They didn't ask the necessary questions. In fact, there's evidence, my lord, in the first inquest from one district surgeon who says it was his policy not to ask questions from security detainees.
not to ask questions or to take notes of the examination. I think that was Dr. Lewis.
Exactly, my lord. And my lord, we will be submitting that this kind of behavior is nothing less than disgraceful. Lord, it is hardly surprising then that the first inquest presided over by Additional Magistrate J.S.P. Kun concluded that nobody was to blame for Haron's death. He accepted the police claims without question. Magistrate Kun played his role in the facade of justice that unfolded in the Cape Town Magistrates Court between February and March 1970.
Before you leave the magistrate, and maybe it's something that we did later in your submissions. At the end, I would like to hear what would be the approach that you think the court should take, especially in the absence of his reasons for his findings. Unless I missed something, but my reading of these files, I was unable to find any single sentence of his reasons for his findings. I only could trace his findings.
Indeed, my Lord, we also searched high and low. How could it be that after weeks of hearing, a presiding officer simply issues a 4-paragraph finding comprising barely half a page without the slightest attempt to explain his findings or substantiate them? My Lord, to suggest that it was a dereliction of duty is putting it mildly.
Welcome. Proceed.
My Lord, we are confident that this reopened inquest will finally unearth the truth of what happened to Imam Haron. The question is why the family had to wait 53 years for this day. And sadly, my Lord, we have to submit that South Africa, and in particular the post-apartheid state, has failed the Haron family and so many other families waiting for truth and justice from cases arising from the apartheid era. Lord, Imam Haron's wife, Galima, died at the age of 93 on 29 September 2019. Lord, exactly 50 years to the day after her beloved husband was buried. Her daughters, Shamila and Fatima, advise us that their mother died with inner peace, composure and dignity. However, my Lord, she went to the grave without the closure she so deserved. Fortunately, in court today, we have the 3 children of Galima and Imam Haron. These are Shamila Shamis, Muhammad Haron, and Fatima Masut. Lord, Fatima was only 6 years old when her father died. Muhammad was 12 years old, and Shamila was 18 years old. Shamila was actually living in the United Kingdom at the time and was unable to attend her father's funeral, which took place in terms of Islamic law. It says that as soon as the body was released, it should be buried. Lord, we think that we should place the life of Imam Haron in context. We need to ask the question, who was Imam Haron? He was born on the 8th of February 1924 in Newlands, Cape Town. He was the youngest of 5 children. After finishing school, he pursued Islamic studies in Mecca for 2 years. He married Galima Sadan in March 1950. They had 3 children. In 1955, Haron was appointed as Imam of Al Jamia Mosque on Stegman Road, Claremont. The Lord, an Imam is a Muslim religious leader, a recognized authority on Islamic theology and law. And an Imam is also a spiritual guide. He founded the progressive Claremont Muslim Youth Association in 1958. And this body published a monthly newsletter known as the Islamic Mirror from 1959. He maintained close association with well-known activists of the day, including Albie Sachs and Robert Sobukwe. Haron raised funds for the Coloured People's Congress, which was banned by the apartheid regime in 1960. He gave Friday sermons and public lectures in which he was critical of the apartheid regime's racial laws. His mosque also ran the Imbaduraman Study Circle that discussed social and political ideas. In 1961, the Claremont Muslim Youth Association began circulating Call of Islam, an anti-apartheid newspaper. At this stage, Haron was in close contact with activists from Langa, Guguletu, and Yanga. He was affectionately known by people in these townships as Mfundisi, a priest. On 7 May 1961, at a meeting at the Cape Town Drill Hall, Haron gave an impassioned speech describing the Group Areas Act as inhumane, barbaric, and un-Islamic. Also in 1961, Haron was involved in organising a general strike in response to South Africa's decision to leave the Commonwealth. In the early 1960s, he delivered sermons emphasising the concept of brotherhood in Islam and urged Muslims to support black South Africans in their fight against the racist apartheid regime. He was closely connected with Barney Desai, an anti-apartheid activist who was prominent amongst the coloured community in the Cape. Through his connection with Desai, Haron began to support the underground activities of the Pan-African Congress, the PAC. In late 1965, while the Coloured People's Congress was functioning underground, Haron became involved as a member. It was also around this time that he was identified as a security risk by Major Genus of the notorious security branch. In 1966, Haron travelled to Mecca with his wife, where he reconnected with Ibrahim Desai, that's Barney Desai's brother. Together, they lobbied members of the Islamic World Council, urging them to intercede with their governments to oppose apartheid. Haron engaged directly with PAC members when he travelled to Cairo and addressed a conference of Muslim representatives, which was attended by members of both the PAC and the African National Congress. He became involved in a plan to recruit young men to undertake short courses of guerrilla training outside South Africa under the auspices of leaving the country to go on Hajj. Haron was also closely connected with Canon John Collins of St Paul's Cathedral in London. Collins had founded the organisation Christian Action and was involved in establishing the Defence and Aid Fund, which, as we're all aware, provided tremendous assistance to victims of apartheid. Haron agreed to disperse funds to those left poor and destitute through their political activities. Around this time, the security branch began to raid the family home and the mosque, looking for incriminating materials. His bank accounts were also scrutinised. The officers who visited his house included Major Genus and Sergeant Speker van Wyk. In December 1968, Haron visited Mecca and Cairo. He also visited the Netherlands and London. The purpose of his trip to London was to make educational arrangements for his daughter Shamala, who wished to become a radiographer. And while in London, Haron confided in Barney Desai. He mentioned that there were informers everywhere and that they were continuously harassing him. They were trying to persuade his employers to fire him. Desai actually advised Haron to leave South Africa or not to return from his visit abroad. Haron's passport was due to expire in March 1969. Haron said that if it was not renewed, he would know that the time had come to leave South Africa. And indeed, we know that the authorities did not respond to his request for his passport renewal. During May 1969, Haron was instructed by the security branch to appear at Caledon Square police station, where he was confronted by a thick file. This file apparently contained information about his 2 journeys overseas and the people he met, such as Barney Desai and Ibrahim Desai. Haron denied their claims, but the officers told him they were not finished with him yet. And now turning to the arrest and detention of the Imam. He was arrested by the security branch on the 28th of May 1969, on the day known as Milad-ul-Nabi, the celebration of the birth of Prophet Muhammad. Van Wyk and another officer arrived at Haron's home and took him to Caledon police station for questioning and to be detained under Section 8 of the Terrorism Act. That evening, he was escorted to his home to collect his personal effects, including his toothbrush and night clothes. And he was told he was to be detained indefinitely. We know he was held in detention for some 123 days without being permitted to see his family, private doctor, or lawyer. Whilst in detention, my lord, Haron arranged for various messages to be smuggled out. One of them was on a piece of toilet paper. It was addressed to Canon Collins. The message stated, "If you hear that I have died in prison by accident, you will know it will not have been an accident." My lord, turning to the version of the state at the time, the constant refrain of the security branch in the first inquest was that Haron never complained. They claimed he always looked well, and when asked, he always said he was fine. This remained the dominant narrative of the police, even when it became apparent that the security branch had taken Haron from his Maitland police station cell on 17 September 1969 and returned him a physically broken man on the night of 19 September 1969. My lord, the version of slipping down the stairs had only emerged later. It only emerged after the completion of the post-mortem report, when it became abundantly clear that an explanation was needed to explain away multiple injuries. This included 27 bruises and a fractured rib. My lord, it turns out that even in 1969, this was not the first time that Speke van Wyk had put up such a fabrication. One Alan Brooks had his ankle broken under interrogation by the security branch in Cape Town and sued the police. Speke claimed that Brooks broke his ankle while fleeing down the stairs in an attempt to escape. Indeed, falling downstairs and falling out of buildings were to become a standard refrain of the security branch to explain horrendous injuries that they had inflicted on detainees under interrogation. It was further suggested by the senior state pathologist at the time, Dr. Schwa, that Haron's anxiety and stress could have resulted in rapid heartbeats, which increased the risk of myocardial ischemia. It was claimed that Haron already had constricted coronary vessels. The police claimed that at this stage Haron was consumed with worry and anxiety since he realized he had been caught out by his interrogators. They claimed that a thrombosis in the deep vein of his calf was attributed to Haron's own negligence in not being physically active and provided the opportunity to exercise while in prison. My lord, to return to the points that you had raised earlier, pathologists, Dr. Schwa and district surgeons, Dr. Beviers and Dr. Gosling, as well as visiting magistrates Barnard and Van Groenen, all attempted to minimize the condition and state of Haron during his ordeal in detention. Both Dr. Gosling and Dr. Beviers refused to ask Haron basic questions that medical doctors ought to have asked and normally ask on a routine basis. They failed to perform proper examinations. My lord, they maintained the facade of a well-treated detainee. The impression given by these witnesses was that Haron was generally well, except for a few aches and pains and some malaise at certain points in his detention, and that he ultimately succumbed to a pre-existing coronary vessel restriction arising from his own inertia. They averted their gaze from the real and dire condition of Haron. My lord, their collective conduct was nothing less than disgraceful. The investigation that followed Haron's death can barely be called an investigation. From what we can ascertain, my lord, no photos were taken of the body at the autopsy, which we believe was customary practice even during those days. and only one photograph of the death scene was provided at the inquest. When statements were taken from security branch members, they were taken and commissioned by other members of the security branch, not the detective branch. And my Lord, we suggest this was likely to ensure some consistency in the cover story of the members involved. Turning to the finding of the magistrate, my Lord, the inquest finding of Magistrate Kun makes for pitiful reading. He accepted the police version without question, or even raising the slightest concern or apprehension about its improbabilities. Bland denials under oath by the interrogators were good enough for him. My Lord, it seemed that Haron's interrogators knew from the outset that they had nothing to be worried about in that inquest proceeding. And if that was the case, my Lord, they were entirely correct. If Magistrate Kun had been engaged in a serious search for the truth, he would have found the evidence of Major Dirk Kotsaginus and Staff Sergeant Johannes Petrus Francois van Wyk, also known as Spyker, to be highly improbable, raising serious questions as to what they were hiding. Magistrate Kun preferred not to ask those serious questions.
It would have been interesting to see this consideration, especially of the fact that from the onset up until at least the station commissioner of Maitland was pressured by Cooper SC's questions to talk about the presence of records of the ins and outs, and that it was at that point discovered for the first time that actually the Imam had been removed from Maitland Police Station on the 17th at around 7:40 in the morning, and only returned on the evening of the 19th, the evening of the alleged. That testimony, unless I missed something on the record, but my understanding is that the security branch members did not say a word about that when they testified until Cooper forced, as I say, the station commissioner to go and seek the records, and it was discovered that actually the Imam had been away from Maitland Hospital, police station, and had been removed by members of the security branch between the 17th and the 19th. But as I say, it's unfortunate that the magistrate did not give any reasons. But it would have been interesting to see what his reasoning was around those aspects, amongst the others.
Indeed, we will expect a reasoned finding. We will have expected Magistrate Kun to probe these questions. Why, for example, during the hearing, did Magistrate Kun not put that question to the relevant police officers? Once, and thankfully through the probing of Advocate Cooper SC, the station commander was forced to bring his records to court and forced to disclose that over that period of nearly 3 days, Haron in fact had been removed. Sadly, nobody asked, why did you not disclose this? Why was this kept from the court? Magistrate Kun didn't pose that question. The prosecutor didn't pose that question. And from what we can see, unfortunately, Advocate Cooper also didn't pose that specific question as to why that information was held back. Because clearly, the security branch intended to withhold that information.
I know we addressed it at one point. I think it was during the Maitland police Administration Commissioner or funding, but there was a time when Mr. Cooper dealt with it. What I missed is, as I said, there are no reasons for the magistrate, but it would be interesting to see what his approach to that testimony was.
Yes. Because quite clearly, one doesn't have to be a rocket scientist to detect the obvious inference to be drawn that the security branch did not want that fact disclosed and had held it back. And indeed, the probabilities are that they imposed upon the Maitland police station staff also not to disclose that. But they were forced to after Advocate Cooper SC requested the production of the police station records.
You're welcome.
As a court pleases. My Lord, before I proceed, I see that it is 11 a.m. and I still have about perhaps 20 minutes to go. Would your
You
Lordship,
can take the tea break once you're done if it's only 20 minutes.
as
If
the
it's going to be more than that, then we take an adjournment at 4 past. And then thereafter take the reply if any from counsel from the state and then we proceed.
as the court pleases,
Yeah.
I'm sure my Lord is aware that often when the council provide estimations that they tend to be
You
somewhat...
realize that council may have passed other things but not time.
Exactly, my Lord, and I must confess that my time management is often wanting or lacking.
You're welcome. Let's proceed and see how far we can go up until 4 there.
Okay.
We'll take the tea break.
My Lord, please interrupt me whenever you wish to take the break.
You're welcome. I think we are around paragraph 39 when I
Yes. So, my Lord, while the family's legal team, led by Advocate W.E. Cooper SC, put up a valiant fight, their cause was doomed from the start. Magistrate Kun curtailed Cooper SC's cross-examination and stopped probing questions on the interrogation itself. For example, he stopped questions dealing with the procedure of the interrogation and instructed Cooper SC not to spend too much time probing the purpose behind the interrogation, as if these matters were irrelevant. Magistrate Kun's finding amounted to 4 paragraphs comprising half a page. He did not even bother to provide reasons to explain or substantiate his findings. My Lord, on the cause of death and the question of responsibility, you have read out the full finding, which took my Lord perhaps less than 2 minutes to do so, because it is thin indeed. I will not read out the finding again. My Lord, given the overwhelming medical evidence of injuries endured by Haron while in detention, Magistrate Kun could not wish away the evidence that trauma endured by Haron led to the worsening of his condition, resulting in his death. Without saying so, Kun had to accept that the claimed staircase fall could not explain all the injuries, given their distribution and pattern, and given that they were of different ages. He attributed, though, a substantial part of the trauma to the police version of an accidental fall down a flight of stone stairs, but claimed that he was unable to determine how the balance of the trauma was caused. This was so even though it was undisputed that all these injuries occurred while Haron was in the custody of the police, and no other explanation was put up by the police. And Lord, we submit that Magistrate Kun conducted himself in a manner that was predisposed to a particular result, namely the exoneration of the police from all wrongdoing. He went out of his way to give the police a veneer of respectability. It was manifest to any casual observer of the first inquest that the magistrate paid little or no regard to the standards of even-handed justice. his manifest bias was plain to see. Lord, we will be submitting that on this ground alone, the finding of the first inquest warrants overturning. And regrettably, my Lord, the obvious bias of Kun was no exception when it came to apartheid-era inquests. George Bezos SC, in an affidavit supplied in the reopened inquest into the death of Dr. Neil Aggett, pointed out that most apartheid-era magistrates dealing with inquests involving the deaths of political activists had no real desire to reach the truth. He noted that some of these magistrates saw it as their duty to protect organs of state, such as the police. He mentioned that magistrates tended not to interrogate police versions that vigorously. And my Lord, this particular case is no different. Bezos SC also pointed out that apartheid-era inquest courts tended to minimize evidence of the ill treatment of detainees. Official police versions were often contradicted by forensic pathologists who examined the bodies of detainees. Magistrates typically ignored such expert evidence and uncritically accepted the versions of police witnesses. Improbable testimony of police witnesses were invariably rubber-stamped by inquest magistrates. Police versions that deceased detainees were treated with care and consideration were readily accepted by the courts, notwithstanding evidence of pre-death injuries. Now, turning to the family's case, I will provide just an outline of the case we wish to present to your Lordship. Lord, we intend to demonstrate that Imam Haron entered detention in good physical health. In a medical examination for an insurance policy at the end of 1967, Dr. Louis Sternberg found him to be in normal health. Evidence will be led that Haron frequently took indigent persons to a doctor's surgery, but he himself never required medical attention. Indeed, my Lord, the security branch members themselves confirmed that when he was arrested, he was in good health. We will demonstrate a definite correlation between Haron's complaints of various ailments, including chest pains, headaches, rectum bleeding, to his interrogation during the first 10 days of July and his last interrogation during September 1969. My Lord, it is the family's case that Haron did not fall down a flight of stairs. This was a story designed by the police to mask the brutality that they had visited upon him. The medical and circumstantial evidence pointed unequivocally to Haron being subjected to considerable trauma through unrelenting torture. This trauma led directly to systemic complications that in all likelihood resulted in the narrowing of coronary artery that ultimately caused his death. My Lord, it will be one of the submissions of one of South Africa's leading forensic pathologists, Dr. Steve Naidu, that but for the unrelenting abuse endured by Haron during his detention, he would not have died at that time. According to Dr. Naidu, the extensive injuries seen all over Haron were mostly caused by blunt force impacts, most likely through assaults. This abuse caused significant physiological trauma that led to systemic health complications which cascaded towards the ultimate demise of the Imam. My Lord, both forensic pathologists, Dr. Naidu as well as Dr. Tumaleng Molefe, dismissed the possibility of the injuries arising from a fall down staircase. This is due to the shape and pattern of the injuries, which are not consistent with typical staircase fall injuries. And my Lord, they also point to certain damning evidence that Haron's injuries were sustained at different dates and times. And my Lord, the allegation is that there was only one fall down the stairs, not multiple fall down the stairs. Lord, we will also lead the expert evidence of Mr. Thavesh Mudli, who is a mechanical and aeronautical engineer. He considered the versions of Major Guinness and Sergeant van Wyk and examined in detail the staircase in question. He carried out his own calculations. Mr. Mudli concludes that the injury pattern on Haron's body do not reflect those typically seen in falls downstairs. He will testify during the course of this week, indeed tomorrow, he will testify that since there was no bruising on the buttocks, the back, aside, my Lord, from a small bruise in the small depressed area of the back, there was no bruising on the neck or head, and considering the magnitude of the impact forces that would have been applied to those parts of the body in such a fall, the police version that all of Haron's injury was sustained during a fall is, in his opinion, not credible. In contrast, there were significant injuries on Haron's chest, inner right thigh and calf, both shins and left hamstring, which cannot be connected to the alleged fall. Lord, we will also lead certain similar fact evidence. This will be from other former detainees, in particular those who were also interrogated by Speaker van Wyk. We hope to demonstrate, my Lord, that the torture endured by Imam Haron was not out of the ordinary. Some will even testify that Speaker van Wyk threatened to deal with them as he had dealt with Imam Haron. Evidence will be led to demonstrate that Haron did not break under interrogation. He did not betray anyone. This would have enraged his interrogators, who then ramped up the torture to new levels, particularly over the period 17 to 19 September, when he was removed from his cell at Maitland Police Station and allegedly taken to various undisclosed locations. We will be submitting, my Lord, that during the period over those 3 days, particularly given that the Imam was not betraying his comrades, the torture rose to new levels of brutality. And we will submit that the torture he endured over this period led directly to his death on the morning of 27 September 1969. My Lord, the old saying, justice delayed is justice denied, is particularly pertinent in this matter. My Lord, the Haron family never expected the apartheid state itself to investigate themselves. However,
maybe before you take on this point, let's take the tea again.
as the court
For 15 minutes.
welcome to proceed, counsel. As the court pleases, the Lord, before I proceed, two housekeeping matters have been brought to my attention. The one is the question of audio, and although I'm trying my best to project my voice, I'm told that family members and those behind us in the gallery are struggling to hear. So there is a request that those of us speaking raise our volume as much as we can so that they can listen in.
Yes. And one thing about the facilities that we have before is that although you have I have a speaker next to me, it's actually not to boost the voice, but it goes directly to the machine to record. So we don't have anything assisting with the audio other than your own voice.
Noted, my Lord, so we will perhaps we'll have to pretend that we are Shakespeare actors in which we have to project the voice. My Lord, I believe that the air conditioning is now working. There were some complaints about the fact that the temperature was on the rise in this court.
Yeah, that's true. It's one of the reasons I thought I shouldn't torture anybody further, but take a short vacation. You're welcome.
Thank you, my lord. But from what I can see, the air conditioners are now working. My lord, just before we broke for tea, I was about to move to a heading in my opening address titled "Justice Delayed is Justice Denied." My lord, interestingly, as far as we are aware, this is the oldest inquest taking place in South Africa, at least one dealing with an apartheid era case, dating back to September of 1969, and certainly of the reopened inquest, it is the oldest one. The next oldest one would have been the inquiry that looked into the death of Ahmed Timo in 1971. Lord, the Truth and Reconciliation Commission looked at a number of cases dealing with deaths in detention, including the case of the late Imam Haron. And Lord, they found that Imam Haron was subject to gross human rights violations. That is a specific finding which we will draw your attention to. They also identified certain of the suspects, including Speaker van Wyk. Lord, sadly, all the security branch members, all of the key suspects in this case, have long died. And we will be providing you in due course with an exhibit with their dates of death. So we will be seeking, we will be suggesting to your Lordship to make certain findings in relation to these suspects that we believe were behind the death of the late Imam Haron. But the Lord will not be in a position to make recommendations, at least in relation to those who are now deceased. The Lord, that of course is a small tragedy that the family will have to live with. But nonetheless, for purposes of the historical record and for purposes of closure, the findings that this reopened inquest will make will be of immense significance. Lord, from what we can detect, also all members of the normal uniform branch, including all those who were stationed at Maitland Police Station, have in fact passed on, with the exception of former Constable Johan Berger. He was one of the constables on duty at that time at that police station. Lord, if the post-apartheid state had acted expeditiously, at least following the winding up of the Truth and Reconciliation Commission, Kgalema Haron could have been provided closure and the truth of what happened to her husband. As I mentioned before tea, the family didn't expect the apartheid state to investigate themselves. They hardly expected the security branch and the erstwhile South African police to carry out a credible investigation. However, they did have expectations of the post-apartheid state, the new democratic order. And my Lord, they have been bitterly disappointed. The TRC referred hundreds of cases to the National Prosecuting Authority, in which amnesty was not applied for or denied, including the Haron case. And my Lord, there is a mistake there, the Haffajee case. I'm dealing with too many of these inquests. We were in Pietermaritzburg court a few weeks ago on the Haffajee case. Apologies for confusing the two case names. We referred to these cases that were referred to the NPA after the winding up of the TRC as the TRC cases. The TRC did request that the NPA look into these 300-odd cases, and typically these were cases in which amnesty was denied or had not been applied for. Regrettably, my Lord, until the last few years, these cases were not seriously pursued. The responsible institutions for many years sat on their hands, and in some cases, they pretended that investigations were proceeding when they were not. My Lord, we led evidence in that regard before the inquest court dealing with the late Imam. Look, we now know why cases from our past have not seen the light of day in courts of law. It has emerged in recent court cases that powerful elements in society shamefully colluded to ensure the suppression of the cases referred by the Truth Commission to the National Prosecuting Authority. If I can refer, my Lord, to a case that came before the Supreme Court of Appeal. In this matter, the SCA dismissed former apartheid security policeman João Rodrigues' bid for a permanent stay of his prosecution of the 1971 murder of Ahmed Timo. Lord, the Supreme Court of Appeal said it was perplexing and inexplicable why these cases were suppressed. My Lord, if I may quote from paragraph 21 of that judgment, the executive adopted a policy position conceded by the state parties that TRC cases would not be prosecuted. It is perplexing and inexplicable why such a stance was taken, both in the light of the work and report of the TRC advocating a bold prosecution policy, the guarantee of prosecutorial independence of the NPA, its constitutional obligation to prosecute crimes, and the interests of the victims and survivors of those crimes. Well, Lord, most of these cases can't be revived. They are effectively dead and buried. As in the Haron case, suspects, witnesses, and family members have died. Lord, the harm visited upon these families and their communities is incalculable. They deserve nothing less than a full, open, and independent public commission of inquiry as to how and why justice was denied to them. Now, while the NPA and SAPS have turned over a welcome new leaf in relation to the cases from our past, regrettably, families are still struggling to have their cases attended to. Even in this matter with its high profile, it took the attorneys during 2019 no less than 3 months to get permission to access Cape Town Central Police Station to examine the staircase in question. In fact, the attorneys, Brother Wenzel, had to write threatening letters in that regard. And Lord, comprehensive representations were made to the NPA on 4 December 2019, seeking the reopening of the inquest. Yet it was only some 2.5 years later, 31st May 2022, that the Minister of Justice formally requested the Judge President of the Western Cape Division of the High Court to designate a judge to reopen the inquest. In order to extract this decision, the attorneys had to place the NPA and the Minister of Justice on terms during September of 2021 and again in April 2022 before a decision was finally taken. Lord, such steps should not have been necessary. Finally, my Lord, let me turn to the impact on the family and community. After Imam Haron died, Galima, his wife, had to move her family from their spacious house into a one-roomed house shared with her mother. Muhammad was sent to live with relatives. We are advised that Galima worked tirelessly as a seamstress to support her family, and she eventually saved enough money to purchase her own home. Fatima's most vivid memories of her mother are of a woman who wasted nothing and toiled day in and day out to provide for her children. Galima's life is defined by her stoic commitment to survive and her devotion to her children. And Lord, Haron's death instilled fear and anxiety amongst many involved in the anti-apartheid struggle. But in other quarters, it ignited a burning fire for change. The Muslim News, on 24 September 1982, published a statement, the South African Students' Association, which is a good example of this burning desire for change. And I quote an extract from the piece. The essence of great achievements is sacrifice. Are we ready? Are we fit? Is our Imam, that's faith, my Lord? Is our faith strong? As Muslims, we are proud, but we are also humbled to acknowledge that such a martyr lived amongst us. A Muslim should at all times be exemplary, even in his death. And such a man, such a Muslim, such a mujahid, is Imam Abdullah Haron. Haron became a symbol of resistance for South Africa's youth in their fight against apartheid during the 1970s and 1980s. And Lord, the Imam Haron Foundation was established in 2019 by the Haron family and other community members. And if I may quote from an extract on the foundation website, it was established in order to share aspects of his humble life with the communities, not only in South Africa, but also in other parts of the world, raise public awareness of the role he played in the Cape community, and teach the current generation about the lives of individuals, such as the Imam, who dedicated themselves to attain and uphold justice, and to always speak and practice the truth. And Lord, the Imam Haron Foundation carries on with the work of commemorating the life of Imam Haron, and they've kept his memory alive through several events, exhibits, and publications. And Lord, Galima Haron died exactly 50 years after the funeral of her beloved husband. This reopened inquest comes too late for her. However, it is of great meaning to Shamila, Muhammad, and Fatima, as well as the wider community. They have lived with the stain of a fraudulent inquest finding for more than 50 years. It is time for that stain to be wiped clean. And Lord, we are confident that this inquest will shine a light on what Imam Haron endured during his 123 days of security detention back in 1969. Imam Haron died for our freedom. It can never be too late for the truth. And all those are opening submissions.
Thank you. I'm sorry, we have anything?
Madam, we are always in the setting. Thanks, God.
Are we ready then to take you? Welcome to Procedural.
Daniel, Dion Peterson.
Please take a full name for the report.
My Lord, my name is Daniel Peterson.
Do you swear that your evidence you are about to give will be the truth, the truth, and nothing but the truth? Please raise the right hand and so sound the court.
So help me God.
Thank you.
Thank you. Mr. Peterson, you may have heard the request earlier, especially from the family and people seated at the back who have come to listen, that we should rather try to speak up so that they follow what we are saying.
Yes, my Lord, I will do so.
Thank you. You're welcome to proceed, Counsel.
Thank you, Mr. Peterson, you kindly place on my court that indeed you are employed by the South African Services.
Yes, my Lord, I am a Lieutenant Colonel within the South African Police Service. My person number is 0622 7376 and I am attached to the Provincial Commissioner's office with my office situated in Claremont. My Lord, I am currently also the commander of the Cold Case Investigative Unit of the Western Cape. The Cold Case Investigative Unit, my Lord, is mandated to investigate all serious cases of violence which are unsolved, including cases relating to the Truth and Reconciliation Commission.
Now, can you just also place for how long have you been in the service?
My Lord, I am now 33 years within the service.
Colonel, is it correct that you have prepared an affidavit in respect of your testimony for this inquest?
It's correct, my Lord.
My Lord, would you have prepared an affidavit signed by the witness? I would ask the stage to be added in the exhibit.
You're welcome.
Now, don't we just indicate, will you take this court and explain how you came about to be involved in this inquest investigation?
Yes, my Lord. My Lord, during August 2020, the death in detention of Imam Abdullah Haron was allocated to me for investigation. The allocation of this investigation came through the Office of the Western Cape Deputy Provincial Commissioner for Crime Detection, Major General J.A. Veery. He was at the time the Deputy Provincial Commissioner for Crime Detection. Prior to the reallocation to me, my Lord, this matter had been allocated to Colonels Tobias and Colonels Jonas, who at the time were attached to the Office of Specific Crimes, falling also under the ambit of the Deputy Provincial Commissioner of Crime Detection, Major General Veery. Now, Major General Veery is no longer within the service of SEPS, and Colonels Tobias and Colonels Jonas have retired.
Can you proceed further, Colonel?
Yes, my Lord, thank you. At the time of reallocation, I received 3 white files, my Lord, marked Weber Wenzel, in brackets, two duplicate files with reference 303-2726 and 1 file reference 25/7/1-201-90096. Haron family RE Inquest of Imam Haron. Brief to SEPS. Ou Geldenhuis. Now, my Lord, the file with the reference number 25/7/2/1 201-90096 was addressed to the National Director of Public Prosecutions, the NDPP, dated the 4th of December 2019, with written representations requesting for the reopening, my Lord, of the inquest into the death of Imam Abdullah Haron in terms of Section 17A of the Inquest Act 58 of 1959. Now, that file, my Lord, consists of a table of contents, an introduction with a background history, and supporting documents, namely a report by Dr. I. Molefe, Inquest 50/1970. That report is not commissioned. A preliminary technical assessment of Imam Abdullah Haron's fall down the flight of stairs, compiled by Thebes Moodley of THI Dynamics. Also affidavits, these affidavits, my lord, were not signed or commissioned that was drafted by the deponents. The deponents are Jeremy Patrick Cronin, Robert Cedric Wilcox, Shirley Renee Gunn, Yusuf Gabru, Zainal Magda, maiden surname I believe was Hendricks, and the testimony of Zubaida Zafar, that is a TRC UWC hearing on the 3rd Wednesday and the 7th of August 1996, case number CT/0076.
Sorry, if I may just interject. When you refer to receiving as part of that bundle the report by Dr. Mulife, would I be correct that it was a preliminary report from the Mulife?
That is correct, yes, my lord.
Continue.
Then, my lord, the duplicate files marked 3032726 were addressed to Major General Vieri, who was at the time the Deputy Provincial Commissioner for Crime Detection, with a request or requesting the reopening of the investigation into the inquest of the death of Imam Abdullah Haron. This request, my lord, was supported by the following documents filed in subdivisions within that file, namely the written representations, a list of persons detained, contact details of Alim Parker, a list of South African police officers, transcript of Jan Burger interview, the Imam's prison notes and letters. The chapter's title, If Courage Goes, and White Lies, that is from the book titled Killing of the Imam. And then, my lord, also an IMF report and various media articles.
Now, is it correct then that you further also embarked upon your own investigation subsequent to your receipt of that file?
That is correct, my lord.
Please take us through.
My lord, upon allocation of the death of Imam Abdullah Haron, I analyzed all relevant information, including the inquest court hearing, that is 50 of 1997 of 70, J300 file number 2/1/1742, and the finding. I then found, my lord, that all the documents are copies. In summary, the deceased, Imam Abdullah Haron, born on 8th of February 1924, was the Imam of El Jamai Mosque situated in Stegman Road, Claremont. He was taken into detention on the 28th of May 1969 and passed away on the 27th of September 1969. Whilst in police custody at the Maitland South African Police Station, where his body was discovered in a cell. An inquest court, my lord, hearing then commenced from the 18th of February 1970, which was concluded on 10 March 1970. copy thereof is attached hereto marked as annexed. This inquest, my lord, was heard by Mr. J.S.P. Koen, who uncovered that the deceased, at the time of his arrest on 28 May 1969, on a charge of contravention of Section 6(1) of the Terrorism Act 83 of 1967, was in good health. Initially, he was detained at Caledon Square South African Police Station, now known as Cape Town Central Police Station. After his arrest, my lord, he was then transferred to Maitland Police Station on the 11th of August 1969, until the day he was discovered deceased in his cell. My lord, whilst in detention, he was continuously interrogated by members of the Safety and Security Branch of the South African Police, namely Sergeant Johannes Petrus van Wyk, commonly known as Spyker, his brother Sergeant Andries van Wyk, and Major Dirk Kotse Kennis. My lord, he was transported to and from the place of detention for the purpose of the interrogation sessions, which took place in the office of Caledon Square Police Station. During his time in detention, my lord, he had complained of chest pains and headaches, and had been examined by district surgeons, Dr. Viviers, on the 7th of the 7th month, 1969, and also Dr. Charles de Archie Gosling on the 10th of the 7th, 1969, the 14th of September 1969, and the 15th of September 1969, where he was always accompanied by members of the security branch and received medication prescribed by the individual medical practitioners. My lord, he was also interviewed on various occasions by the then Chief Magistrate of Cape Town, A.J. Barnard.
Maybe before we go to the visits by the Chief Magistrate of Cape Town at the time, it seems from my reading of the records that at all times that the medical personnel examined the Imam, members of the security branch were in that.
That is correct, my lord.
At one point, the impression that I get is one would be physically where the examination is taking place, and one would be around the door. That's my reading, especially the visits to VS and the understanding of the evidence of both VS and Spain.
Yes, my lord.
So the doctor's examination of the Imam was not private.
Not at all, my lord.
Welcome, Professor.
My lord, he was also interviewed, like I said, on various occasions by the then Chief Magistrate of Cape Town, A.J. Barnard, and Magistrate Barnard and Grenen during judicial inspections into conditions of detention at the police cell, where he was detained alone, despite his complaints of his medical condition. He was continuously interrogated.
Going back to the chief magistrate's visits, it also seems to me that these visits were also not right, in the sense that the Imam never had an opportunity to confide in the magistrate in the absence of members of the security branch. It seems to me that the security branch was always there.
My Lord, if you see how the doctors or the medical practitioners visited the Imam with the security branch, then that is my assumption as well, that when the magistrates were there, the Imam was never alone, they were also present.
I see.
Thank you. You're welcome.
Thank you, my Lord. Despite his complaints, like I said, my Lord, of his medical conditions, he was continuously interrogated. It was reported that on the 19th of September 1969, the deceased slipped on the stairway leading down from the office at Caledon Square police station after one of these interrogation sessions. According to Major Dirk Kotse Genis and Sergeant Johannes Petrus van Wyk, my Lord, he did not sustain injuries because of that incident and therefore did not receive medical treatment. On the 27th September 1969, the deceased was found dead in his cell at Maitland Police Station. My Lord, the post-mortem examination was conducted by Dr. T.G. Suar, who made certain observations as to the condition of the body where bruises were noted on the legs and the chest area. The finding of the pathologist was that the mechanism of death were coronary arteriosclerosis.
Can if you don't mind if I interject that point? Are you able perhaps to also just go to the paragraph 10 and proceed there?
Yes. Yes, I will do so.
Maybe just before we proceed, my observation is also that prior to the post-mortem, once the Imam's body had been removed to the mortuary,
Yes, my Lord.
Genes and Spijker went to the mortuary. Is that your understanding as well?
That, my
That
Lord,
they went to examine the body. Before, if my memory serves me well, they even went to the family on their way to disclose the death to the family. Genes and Spijker went to the body.
that was my thoughts as well, my Lord.
And it seems to me that they would also have been present during the post-mortem.
All along.
And it also seems to me that this version of a sleep on the stairs arose contemporaneous with the post-mortem or thereafter. In other words, the fall, the alleged fall, happened on the 19th of September, right?
Correct, my Lord.
And The death happened on the 27th.
Correct, my lord.
But before this discussion that I had with you, the visit to the body and the post-mortem, there was no report about the alleged fraud. In other words, between the 19th of September 1969 and the 27th of September 1969, the date of death, Spijker and Genes never reported or recorded anywhere that the Imam on the evening of the 19th of September slipped and fell at the police station.
My lord, I couldn't detect such a report during that period.
Thank you. You're welcome to proceed, counsel.
My lord, after this analysis, I then advanced with the investigation. And I registered a inquiry, PCOM Inquiry, Provincial Commission Inquiry 4/5/2021, in concurrence with the Office of the Director of Public Prosecution of the Western Cape.
So can you just double check if at this particular point where you advanced with your investigation, registering this inquiry in conjunction with NVA, is it in 2019, June 2019, November?
My lord, as I said, I received this investigation in August 2020.
During COVID, I'm just thinking loud.
Yeah,
I see.
was at the awkward time, my lord, with COVID. Now, my lord, during the course of my investigation, I attempted to trace the original criminal case docket and the original inquest record pertaining to Mr. Abdullah Haron. I contacted the Maitland police station, the place where he was found deceased, to ascertain whether they could trace any docket pertaining to Haron's death. And I was informed, my lord, that no records were in existence. I attached an affidavit from Jacob van der Merwe, who is employed as an archive clerk at Maitland Police Station. And that statement is marked as Annexer DDP 1.
Sorry, my lord, if I may just interject. Perhaps it is prudent at this stage, my lord, as reference is made to the initial inquest report that is annexed to Colonel Peterson. If I may ask that we at this formally hand up to the court that meeting. I have prepared further paginated copies thereof, my lord. Through the court, if I may therefore, my lord, ask them to get it up. My lord also would note that the original inquest record was exhibit from A to V. I would also then ask in relation to the affidavit of Colonel Peterson, then it continues from exhibit W.
What would be the exhibit number?
Exhibit W. That proceeds from volume B.
Yes.
And the initials will also be found there.
Thank you, counsel.
Exhibit W1. Thank you, madam. May I proceed, Colonel Peterson?
Thank you, my lord. My lord, then I also attempted to trace the following registers. The SAP-10, the occurrence register, the pocketbooks of members who interrogated Haron, as well as the SAP-14 log sheet and escort duty logbook pertaining to Mr. Haron. My lord, I was unable to trace any of the stipulated registers. and I attach an affidavit of Marlene Pietersen, who is also employed as an archive clerk at Maitland Police Station, which is marked Annexer DDT 2. Furthermore, my Lord, I approached for assistance in this regard the Office of the Western Cape Legal Service of SAPS, our Provincial Legal Office. I was informed through the head that no records exist for these members, and I attached an affidavit from Patricia Janet Bruder, marked as Annexer DDP3. Then, my Lord, as my investigation continued, as part of my investigation, an attempt was made. I attempted to trace the original inquest and the record of Haron inquest number 50/70 at the Cape Town police station. I see it's two areas, magistrate court, it should be police station. This was also unsuccessful, my Lord. And I attached the affidavit of Captain Yolanda Kotze pertaining to her efforts to obtain the inquest records. And that statement I attached as Annexer DDP Mark 4. Furthermore, my Lord, in compliance with the policy of Department of Justice, all inquest records are destroyed after 10 years. I also attach here to the copy of the policy, handed in as an exhibit in another matter from Department of Justice, reference 27/2/3, Archives A10, Annexer DDP5. My Lord, during the course of my investigation, I received a digital copy of our own inquest file, which was transcript and which was obtained from the Office of the South African National Archives based in Pretoria. My Lord, it was a complete inquest record under Inquest 50/70, held at Cape Town in the District of Cape on the 18th of February 1970, marked Volume A1, pages 1 to 169. My Lord, I also obtained a copy of the full exhibit record, marked Volume A2, containing Exhibits A to V. The inquest, my Lord, was recorded in the language of Afrikaans. It needed to be translated into English medium. The service of Inlexo Innovative Legal Solutions were utilized to translate the record from Afrikaans to English. It is attached here to my Lord and marked as Volume A3, pages 1 to 248. I also attach here to an affidavit from Ms. Zahira Adams Ngope from the Departments of Sports and from the Department of Sports, Arts and Culture, and I marked it Annexer DDP 6.
Can I just interject? In as far as you receiving the electronic digital copy of the said inquest and said statement from National Archive, were you personally visited the archive in Pretoria?
No, my Lord. I sent Captain Nyker, who's also at the time worked at the cold case investigative unit. I sent him down to Pretoria. He himself visited the archives and he retrieved the information there.
And the information was turned over to yourself.
That is correct, my lord.
Proceed.
Thank you. My lord, further as part of my investigation, I visited Maitland Police Station where Mr. Haron was detained. The cell in which he was later found deceased was photographed. A photo album was prepared in respect thereof, my lord. The official police photographer, Sergeant Zianda Sijora, stationed at the Criminal Record and Crime Scene Management Division, Cape Town, prepared an album and I marked it Annexer DDP 7. My lord, Cape Town Police Station, previously known as Caledon Square Police Station, where Mr. Haron was interrogated and detained for part of his detention, I also visited and photographed accordingly by Constable Siabonga Lawrence George, stationed at the Criminal Record and Crime Scene Management in Cape Town. He also, my lord, prepared an album and I attached the same album herein marked Annexer DDP 8.
Now, so to the chief, again, Karen Peterson, is it correct then that the two respective points which were subject of the photographer album are the ones that are due for inspection in local tomorrow? Is that correct?
That is correct, my lord.
Kindly continue, Karen Peterson.
Thank you, my lord. My lord, of the police officers who were directly or indirectly involved in the interrogation.
I'm sorry to interrupt, Lieutenant Colonel. Maybe before you leave that area, these respective scenes, to your knowledge, has there been any changes to them between 1969 and today? Let's start with Maitland Police Station.
My lord, officially we didn't get clarification on that, but meaning documents or drawings or plans with regards to that.
Yes.
But if I can recall the one witness that is still alive, I asked him specifically, and his remark was, it's still the same as it was that time.
Is it the one at Maitland Police Station?
At Maitland Police Station,
Right.
yes.
In other words, you're talking about one of the police officers who were contemporaneous with the period of the detention of the Imam, who says what you visited recently in Maitland, in particular the cells and its surrounding and all the relevant areas, are still the same as they were in 1960.
Yes, my lord, except that he said with regards to the cell door, there was a little hole in the middle, which you can see through. That
So
isn't the same
That was
anymore.
the only change.
Yes, my lord.
But otherwise, the cell is as it was in 1960.
That was his remarks to me as well.
So when we visit the scene tomorrow, the court can simply assume that, but for that cosmetic change, what we will be seeing would be the position as it maintained in 1969.
And then I just remember now, he also pointed out in that same cell, my lord,
Yes.
there is now a bed, a built-in bed with cement.
Yes.
That wasn't there at the time of the Imam's detention.
All right.
That wasn't there. And then he pointed out that the toilet, I think it's moved.
I see.
Other than that, everything
The
is...
scene is still the same.
Yes, yes, my lord.
I see. And Caledon was the Cape Town police station?
My Lord, I have no official correspondence to confirm today in court that it is still in the same condition as it was then.
I see. Thank you. You are welcome to proceed, counsel.
Thank you.
You may proceed, Kenneth, perhaps during your testimony it is correct. We also go through to the request made on the public works in relation to the architectural structure of the two scenes. Is that correct?
That is correct, my Lord.
Before we get to that, let's just proceed from paragraph 17. I believe that's where we left.
Thank you, my Lord. Of the officers who were directly or indirectly involved in the interrogation of Haron, only former Constable Johannes Hendrik Hannekom Burger is alive. I made contact with him on the 9th of September 2020. My Lord, he accompanied me and the prosecution team to Maitland Police Station for pointing out, and he is also available to testify. My Lord, as I ascertain,
If you don't mind, I'll just do that check there. In reference to the particular officer, is it correct that he was subpoenaed because of testifying in the proceedings?
that is correct, my Lord.
And the service was confirmed.
It was confirmed, my Lord.
Thank you. You may proceed, Kenneth.
Thank you. My Lord, I ascertain that the following police officers who were also involved, directly or indirectly, with Mr. Haron are deceased. I have obtained proof of death through the Department of Home Affairs for the following police officials. Major Dirk Kotse Genis, annexer DDP 9 in brackets I, or Roman I, Roman 1. Captain Ibanus Jochimus Johannes Geldenhuys, annexer DDP 9 in brackets Roman 2. Captain Peter Louis Malan, annexer DDP 9 in brackets Roman 3. Sergeant Petrus Jacobus Rademeyer, annexer DDP 9 in brackets Roman 4. My Lord, now during the course of my investigation, I also ascertained that the whereabouts of the witnesses who was either directly or indirectly involved with Mr. Haron during his period of detention. I determined then that Mr. Haron is survived by 2 children. This is a mistake, it should be 3 children. And grandchildren, namely Muhammad Haron, Fatima Haron, and then Shamila is the other daughter. And his wife, Khalima Haron, subsequently passed on in 2019. My Lord, I subsequently obtained a statement from Mr. Muhammad Haron. It is attached and marked as Annexer DDP 10. The 2 surviving children, or the 3 surviving children are still available to testify. My Lord, I continue with the investigation. Then I consulted with and obtained a statement from Mr. Yusuf Gabru, a detainee and former anti-apartheid activist who will during evidence shed light on systematic torture by security branch members in Cape Town. My Lord, he was detained during 1975 and subjected to interrogation and torture by the same security branch officers who interrogated Mr. Haron. I attach his statement, my lord, as annexed DDP 11, and he will also be testifying to that effect. My lord, I also traced witness Mrs. Zanil Magda and obtained her statement. She is the niece of Mr. Haron, who was employed as the secretary to Dr. Kotwal, who was the general medical practitioner of Mr. Haron prior to his death. Her statement is also attached as per Annex DDP 12. Hello, during the course of my investigation, I also obtained a statement of Mr. Umar Khan. Mr. Khan was utilized by the security branch to attest to a letter that his brother, at the time also a detainee, who was incarcerated simultaneously with Haron, was well received and well treated by the security branch. He also, my lord, had to praise the security branch for the treatment of his incarcerated brother. This was done to secure the release of his brother to attend their father's funeral. His statement I took dated 30 November 2021. And I attach it, my lord, as Annex DDP 13. Unfortunately, my lord, Mr. Khan passed away on 16 February 2022. His death certificate is attached as per Annex DDP 14. My lord, I also obtained the detainee file of Mr. Haron from bundle of files from the South African National Archives, and that I also attach, my lord, as Annex DDP 15. My lord, during the course of my further investigation, I also requested a list of police files from the Office of SAP's Legal Services in Pretoria. That files, my lord, are not attached.
Sorry, can I just understand that those files are not attached for the purposes of your first affidavit that you deposed to, for them prepared?
I didn't follow.
Can I just understand that the files you're referring to that are not attached, is it at the stage when you prepared?
That is correct.
Affidavit?
That is correct. That is correct, my lord.
Please proceed.
I also then, my lord, attached a list of the number of documented detainees that died while in detention within the South African Police Force, marked Annex DDP 16. That list, my lord, forms part of evidence in other reopened inquests throughout the country. My lord, I also obtained a list of security legislation that was utilized by the security branch to justify incarceration. They are the suppression of Communism Act 44 of 1950, marked DDP 17 in brackets Roman 1. The General Law Amendment Act 37 of 1963, marked DDP 17 in brackets Roman 2. The Terrorism Act number 83 of 1967, marked DDP 17 in brackets 3 Roman 3. The Internal Security Act number 79 of 1976, marked DDP 17 in brackets Roman 4. The Inquest Act 58 of 1958, my lord, marked DDP 17 in Romans 5. And the Promotion of National Unity and Reconciliation Act 34 of 1995, marked DDP 17 in Romans 6. My lord, I continued with my investigation.
Just before we proceed further, the first 4 pieces of legislation that you read, it's amongst others pieces of legislation that allowed the detention of persons without an appearance in court, and sometimes, like in the instance of the Imam, denying that person during that period of detention to have any contact whatsoever with their families, friends, lawyers, and sometimes even medical personnel.
Correct, my lord.
Thank you.
My lord, I continue with my investigation. I also refer to the following published books, articles, and reports as per Annexer DDP 18. And those published books, articles, and reports are Detention and Torture in South Africa by Professor Donald Foster, marked DDP 18 in brackets Roman 1. And then also No One to Blame by Advocate George Bizo, SC, marked DDP 18 in brackets Roman 2. And also, my lord, Killing of Imam, marked DDP 18 in brackets Roman 3. Then, my lord, I contacted Mr. Ferguson Khanas from the Department of Public Works to obtain the architectural plans for both Maitland Sets and Caledon Square as they were in 1969. After numerous attempts, my lord, no procure saying it was not obtained. I couldn't get in.
So in simple terms to the nation, the Department of Public Works is unable to assist this court as to whether there were any structural or architectural changes to the Maitland Police Station as well as the Caledon Police Station or the Cape Town Police Station, at least with specific 2 areas. The Department of Public Works of the Republic of South Africa is unable.
Correct, my lord. We received no response.
Can I just once again just ask in relation to also the paragraph 28, that also relates to yourself having prepared that first set of affidavit at the time of preparation of the affidavit. Yes. You proceed?
I also have obtained a copy of the medical legal or post-mortem report Exhibit HS, my lord, of Mr. Haron, conducted in 1969. And I attach it as DDP 19 in brackets Roman 1. For ease of reference, Exhibit H was also obtained. It reflects the deceased as he was found deceased in his cell in 1969, attached as DDP 19 in brackets Roman 2. My Lord, Exhibit F depicts the original staircase as it was in 1969. It is also attached for ease of reference as DDP 19 in brackets Roman 30 and DDP 19 in brackets Roman 4. My Lord, I further also obtained the service of a pathologist, Dr. Itumeleng Molefe. After the investigation and prosecutorial team approached her for assistance. My Lord, I provided her with the inquest record as received from the National Archives. She cited language difficulty initially, my Lord, in fully comprehending the full initial inquest record, including the post-mortem report. An official translation was transcribed and duly handed to her. Dr. Molefe, my Lord, is available to testify during this inquest as per her final findings. A statement, my Lord, is attached here to mark Annex DDP 20. With regards to my first statement, my Lord, that is all I wish to declare.
I also can correct that Dr. Molefe is an employee of the state and is also subpoenaed with a confirmed receipt.
Correct, my Lord.
I understand also that was the first set of you deposed prepared affidavit.
That is correct, my Lord.
Kindly then Ms. Peterson take us to subsequent prepared affidavit. And the second supplementary affidavit, also with an illness. Is that correct?
That is correct, my Lord.
Could you kindly take the court to in respect of that investigation?
Yes, my Lord. Like I said, my Lord, with regards to my rank, I'm a lieutenant colonel within the South African Police Service. As stated, my personal number is 0622-7376, and I'm attached.
I don't think you need to repeat that part.
You just proceed correctly.
You can just proceed to the gist.
Paragraph 2.
Thank you, my Lord. My Lord, I further confirm that I am the investigating officer in the reopening of the inquest into the death of the late Imam Abdullah Haron, and I hereby submit a supplementary affidavit in respect more information that has come to my attention during my investigation into this matter, which have subsequently come to light. Firstly, my Lord, with regards to my investigations into the related Truth and Reconciliation Commission ERC cases, my attention was drawn to the final ERC reports, especially, my Lord, Chapter 1 of Volume 3, where the Commission noted its finding in relation to the death and the detention of the Imam and the circumstances surrounding his possible torture leading to his death, and the possible implicated perpetrators thereof, namely, inter alia Sergeant Johannes Petrus Francois van Wyk, also known, my lord, as Spyker. In that finding, it is page 104, and I attach a copy of...
Is that 104 is 406?
Sorry, humble apologies, 406, my lord.
That's the paginated file.
That is correct. I attach here to a copy of the relevant report marked Annexer DDP 21 in two files marked Part 1 and Part 2. Secondly, my lord, in relation to any possible surviving police officers involved in the detention of the Imam at the time, I received from the Department of Home Affairs breached death certificates for the following members: Karel Johannes Freisen Pinaar, Petrus Jacobus Rademeyer, Ibanus Johannes Geldenhuys, and then Dirk Kotse Genis. These are attached and marked as Annexer DDP 22 in brackets 1 to Roman 4. Thirdly, during my investigations, I had made, my lord, several attempts at obtaining personal police files of the members involved from SAP's head office based in Pretoria. These were a joint request from the NPA Procedural team, and I also as the investigating officer. My lord, attached here to is a copy of the correspondence, and I mark it as Annexer DDP 23. My Lord, General Groenewald, the head of the litigation administration in Pretoria, subsequently informed me that 8 of the 9 requested files were traced but could not be removed from the office or couriered elsewhere. I was informed that I personally had to attend to those office to make copies of those original files for collection on the 28th of September 22.
Can I confirm, Peterson, that this is in Pretoria,
That is in Pretoria, my
where
lord.
the files were retrieved?
That is correct.
What's it?
My lord, these files pertain to the following members and are attached as Annexer DDP 24, Roman 1 till Roman 8. First one, my lord, ID number.
You can proceed with the names,
Okay.
first names and last names, and you can indicate if you receive the last name.
Thank you, my lord. First name is Dirk Kotse Genis, received, my lord. Peter Louis Malan, not received, my lord. Petrus Jacobus Rademeyer, received, my lord. Karel Johannes Freisen Pinaar, received, my lord. Ibanus Jochimus Johannes Geldenhuys, received, my lord. Johannes Petrus Francois van Wyk, received, my Lord. Petrus Erasmus, received, my Lord. Johannes Hendrik Hannekom Burger, received. Andries Jacobus van Wyk, received, my Lord.
Now, Kilograsson, I require that also for you of yourself obtaining these files, you have to provide full identity numbers and personal numbers for the requested officers.
Correct, my Lord.
And you can proceed.
My Lord, I further requested General Groenewald to provide a statement in respect of the search of the aforementioned documents, and that I attach and marked as Annexure DDP 25. Fourthly, my Lord, I attended a pointing out at the Maitland Police Station on the 9th of September 2022, where the last surviving police member, Johannes Hendrik Hannekom Burger, was present to indicate the cell in which the Imam had been detained and found deceased. My Lord, a copy of the photo album as compiled by LCRC, the Local Criminal Record Center, is attached hereto and marked Annexure DDP 26. And then lastly, my Lord, the legal services of SEPS was given notification of the pending reopening of the Haron Inquest as a potential interested party to the proceedings. They noted the information, however declined to send a representation to attend and participate in the process. Attached to this is a copy of the correspondence, which is marked Annexure DDP 27. My Lord, that is all I wish to declare or state.
My Lord, I do note that we are now sitting executive. One, there is one part of the evidence of the officer that I wish to canvass in relation to the police files, which would be my last part of the testimony before I will take a seat, my Lord. However, we may maybe leave that for when we return.
How long do you anticipate that will take?
My Lord, approximately 20 to 25 minutes, my Lord.
Okay, I think that is better than we are here.
Indeed, my Lord.
If it's more than 10 minutes, it's worth an adjournment.
Indeed, my Lord.
Thank you. We'll resume after lunch. I'll be available as soon as the files are ready. So that is
Rise.
Thank you. The court resumes. I just have to indicate that I have indicated to the support structure to say, look, I get the impression from reading the record that the Imam was a man of warmth, but it doesn't mean that we have to be in this heat necessarily. So I am told that going forward there will be attention to the ventilation in the court, so that from tomorrow going onwards it will be better than today. But surely today we are experiencing that warmth. Thank you. Councillor, you're welcome.
Colonel Peterson, I would like to remind you that you still under the oath.
Correct, my
Thank
Lord.
you.
Lieutenant Peterson, for the last lunch adjournment, you have taken the court to supplementary affidavit till completion. Is that correct?
That is correct, my Lord.
Now, if I may just, by way of just go back and clarify, you mentioned in the affidavit, and that's in paragraph paragraph 5. Legal Services to the Office of General Pretoria. Is that correct?
That is correct, my lord.
Now, can you just maybe explain to the court what is meant by police files, or what are police files?
My lord, the police file referred to here is a administrative file, correct? It's administrative file that the employer is keeping a record of each member within the SA Police Service. That record will, the content of that record will be is the member's leave application. That can be your annual leave, sick leave, any injuries on duty, off duty. It can be personal details of the member itself, pertaining his marital status, and then it can also be his emotional record, how he grew in the organization from whatever rank he started with, and he might end off in SEPs. And then also in that record, my lord, will be if there were any misconduct committed by the member, then there will be a record of that as well in his personal file.
Now, can I confirm if you have gone through the contents of each of the files that you received from the police members that you mentioned, either directly were involved in the detention of the late Mr. Haron?
Yes, my lord.
Are you able to perhaps indicate whether there was any indication that you noted in as far as the files of officers in relation to, or with reference to any offences that may be perhaps highlighted in the files of the members?
Yes, my lord.
Can you present the court to which file members you have actually noted that point?
My lord, I checked the file of JPF van Wyk, parcel number 76279/2.
Can you just place the full names of JPF van Wyk?
My lord, he will be Johannes Petrus Francois van Wyk.
Proceed.
That's the man the evidence suggests was nicknamed Speaker.
Correct, my lord.
Yes.
My lord, what I detect in this file is in that same volume, page 1714, is a written death certificate. Also,
Just pause for a second. Now, if I'm correct, you are referring to page number 1714,
that is correct, my lord.
the paginated page number. And you say that that's a death certificate.
A death certificate for Johannes Petrus Francois van Wyk.
The present record, the date of death.
Date of death, according to this certificate, my lord, is 12 of 11th month, 1990.
Procedural academy, if there is anything of particular importance that you would also want to clarify.
My lord, then I,
Just before you proceed further, Karen, would I understand also that the death certificate of this particular person was not part of the other death certificate that you received from the Home Affairs previously as you testified?
no, it wasn't part.
If I'm correct, it will be the first time it is filed, whether you get confirmation of death of the same.
Of his death, yes. Correct, my lord.
Then we proceed, Karen.
My lord, then I went through the file and then I go through the part of the members SAP 96. It's SAP 96, my lord. Let me just get there.
Just because with the page reference number plates and paginated numbers.
Okay, the page number I am now, my lord, is 1909. Extract from service record. And then on page 1910, it's in Afrikaans, and I'm going to read it like it is, my lord. It's okay with you. Thank you, my lord. Klagtes teen die lid aangeteken. 1A 19 Februarie 1948 Maitland ROM.61.2/1948 weer aanranding Abdullah Arendse KK klaar beweer dat terwyl hy om 10:05 namiddag vensters gekyk het in voortrekkerwag weg Maitland, het hy deur 2 lede van die mag in uniform aangerand was, deurdat beide hom met die vuis geslaan het. C. Op die 25ste April 1948 PG weier om te vervolg. Then, my lord, second, I 10de Mei 1958 Woodstock ROM.127/05/1958 aanranding Leslie Walker KM klaar beweer dat hy by die polisiekantore te Woodstock aangerand was deur die lid en 3 ander lede van die speurdiens deur hom met die vuis te slaan. Dan C onder dieselfde punt 2 die 30ste Mei 1958 PG weier om te vervolg. Dan nommer 3A die 6de van die 7de maand 1964 Kaapstad ROM.6579/1964 aanranding Lenet van der Riet MV klaagster beweer dat sy tydens aanhouding deur die lid ondervra en toe aangerand was deur haar met die oop hand verskeie kere te klap. Dan C op die 18de van die 12de maand 1964 PG weier om te vervolg. Dan nommer 4, my lord, die 2de van die 8ste maand 1964 Kaapstad ROM.722/9/1964 aanranding Stephanie Kemp MV klaagster het beweer dat sy tydens aanhouding en ondervraging deur die lid aangerand was, deurdat hy haar met die plat hand in haar gesig geklap, haar hare getrek en die kop teen die vloer gestamp het. C op die 20ste van die 4de maand 1965 PG weier om te vervolg. Nommer 5, my lord, 5A 2 Augustus 1964 Kaapstad ROM.460/9/1964 aanranding Ellen Keith Brooks WM klaar het beweer dat hy tydens aanhouding en ondervraging deur die lid en nog 'n persoon aangerand was, deur hom met die vuiste te slaan, te wurg en sy bene te draai. Op 5C op die 6de van die 10de 1964 PG weier om te vervolg. Then my lord, number 6 A 22 Augustus 1968 Maitland ROM 88/8/1968 AO 138 en 1 ordonnansie 21 van 1966 nalatige bestuur. Bertie Goslet klaar het met sy voertuig voortrekkerweg Maitland gekruis en in die middel van die kruising tussen twee wit strepe stilgehou. Die lid het met voortrekkerweg gery en met die regterkant van die klaar se voertuig gebots. Hy was van diens. 6C onder dieselfde die 6de van die 11de 1968 skuldig bevind soos aangekla en gevonnis tot R30 of 20 dae gevangenisstraf boete betaal. Nommer 7, my lord, siviele eis deur Stephanie Kemp wat voortspruit uit beweerde aanranding Kaapstad RON .722/9/1994. Na beraadslaging met en in opdrag van sy edele die minister van Justisie is die aksie op die volgende basis geskik. A. Dat die eiseres 'n bedrag van R1000 in volle vereffening van alle eise wat sy teen die verweerders mag hê, betaal word met koste op die Hooggeregshof tarief. B. Dat die verweerders die skikking aangegaan het sonder enige erkenning van aanspreeklikheid en om 'n einde te maak aan die geding voertuie. En C. Dat die eiseres die aksie dadelik staak. Nommer 8, my lord, siviele eis deur Ellen K. Brooks wat voortspruit uit beweerde aanranding Kaapstad ROM 460/9/1964. Die eiser het die aksie teruggetrek. My lord, then number 9, siviele eis deur mevrou G. Haron wat voortspruit uit die dood van haar man Imam Haron terwyl in aanhouding deur polisie. Die saak is geskik deur 'n ex gratia betaling deur die staat aan die eiseres.
Now, Chair Peterson, you understand it correct?
Let me just say, Mr. Machiavelli, ek het 'n boerbok baie jare gelede in Barmak in gesleep. So ek verstaan nog verklaar. Do you understand?
Ek verstaan ook.
Counsel?
Do you also follow what was being said? I'm just trying to determine whether we will need an interpreter for this also or not.
Lord, I think from the perspective of counsel, we were able to follow. That's unclear to us whether perhaps those in the gallery would appreciate translation. This is the Western Cape, so perhaps there are many Afrikaans speakers here, but that's a decision for your lordship.
I see. Mr. Machiavelli, but is your
Lordship, I'm quite happy to follow through, Lordship. I'm quite satisfied.
I see. I will just say, should the need arise, we'll revisit that aspect.
Certainly, thank you. Certainly, my lord. May I then proceed, my lord?
You will.
I take it that Colonel Peterson, that is the only page that relates to the charges that were preferred, that appear in the profile of Mr. Abe.
My lord, there is also one proceedings of a trial. It is page 1894.
But perhaps, Colonel, before we proceed to that page, if we just go back to page 109 and 10. So my understanding is that in as far as the offences listed in 1, 2, 3, 4, 5, that relates to the counts of all of those counts, the then Attorney General declined to prosecute.
Yes, my lord, die PG weier om te vervolg.
And it appeared only that it would be the contravention of the negligent driving that was only a guilty fine.
Correct, my lord.
Safe to say that 79 will relate noteworthy of all counts 1, 2, 3, 4 complainants, however the settlement, civil settlement. Do you understand it correctly?
That is correct, my lord.
Thank you. We can proceed then to the next Karen.
My lord, then, as I said, page 1894, it's proceedings of a trial. This was a disciplinary trial which was conducted by, it was against force number W24397F, Johannes Petrus Francois van Wyk. And the officer who did the trial was Lieutenant Colonel M.J. Fisher. And it was conducted the 5th day of June 1981 in a room 181, first floor, Caledon Plain, Cape Town, at 9 o'clock. And Mr. Johannes Petrus Francois van Wyk was charged for contravening section 58 in brackets 19 in brackets A, small a, of the regulations published under government notice R203 in Government Gazette 719 dated the 14th February 1964. In that peril on or about the 10th of October 1980, he did wrongfully and unlawfully onder die invloed van drank was. The accused pleads guilty, skuldig. Judgment, skuldig. Hy was op bystanddiens. Vonnis met R10 beboet. Die plek Kaapstad, datum 1981, 06/05, en dan het kolonel Fischer dit onderteken en die afdelingskommissaris het dit ook onderteken, my lord.
Now, beside further, there be any other offences that you noted from the file?
No, my lord, that is what I have detected in Mr. Van Wyck's file.
Are you able to confirm whether the police files will also contain any merit medals accomplished by any particular police officer?
Yes, my lord.
Could you maybe also note any of those in relation to the files that you obtained?
My lord, yes. Page 1905, 1905.
Which member are you referring to still?
I am referring to number 24397F S streep Sergeant Johannes Petrus Francois van Wyk.
Yes. Proceed. Can you any relevant portion in relation to those accomplishments?
My lord, as stated on this report, it is a geskiktheidsverslag. It's quite a lengthy report.
Please can you refer to any portions that you deem relevant for purposes of placing on record with whether any matters were or merit?
Yes, my lord. In the same geskiktheidsverslag, paragraph 2. My lord, it's also in Afrikaans. Can I proceed reading it?
Welcome.
Thank you, my lord. As maybe I must place it on a record, this report was written by H.W. Thompson. En it reads, as ondersoeker van misdaad en veldwerker aan die veiligheidstak het die lid goeie ondervinding en nuttige kennis opgedoen wat hom handig te pas kom in sy werksaamhede as veiligheidsman. Die lid het hom onderskei met die ondersoek van misdrywe gemik teen die veiligheid van die staat en goeie resultate gelewer. Hy het veral 'n leidende rol gespeel met ondersoeke van die Uchi Chen Club, African Resistance Movement, Association of Young Africans, die saak teen Jack Terris, 'n gelyste kommunis wat 12 jaar gevangenisstraf opgelê is weens sabotasie, 'n saak van vervalsing van geboortesertifikate, persoonskaarte en paspoorte wat gepleeg is met die doel om persone onwettiglik tot ander rassegroepe te laat registreer en om mense onwettiglik die RSA binne te bring. Die ondersoek teen hoofletter I, Haron en die APDUSA saak wat nou in Pietermaritzburg afgehandel is.
And you say that the report was commissioned by H.W. Kotze.
Correct, my lord.
When was the report dated?
Kaapstad 7/4/1972.
Is there any further remarks that you from the said report?
From the said report, my lord, under page 12, under paragraph 12, kommentaar op klagtes teen die lid geboekstaaf. daar is 'n opskrif, dit is the heading in that same report, my lord. Under paragraph 12. It is on page 1908. Punt 1. Die prokureur-generaal het op alle klagtes van beweerde aanranding geweier om te vervolg. Die beweerde aanrandings ingedien deur Van der Riet, Kemp en Brooks, asook die siviele eise deur Kemp en Brooks, spruit voort uit die ARM ondersoek wat met sukses afgehandel is. Die tipe persoon wat hiermee gehandel het en hul vyhandigheid teenoor die staat en die veiligheidspolisie is bekend en ondersoekbeamptes is tot die uiterste getuig. Alhoewel aanrandings nie goed gepraat kan word nie, het ons natuurlik met die geharde linkse persone te doen wat nie maklik praat nie.
My lord, I would follow that very well. You can just place that for the other.
You also following that, Councillor?
Indeed.
Thank you.
Now, can I criticize in relation to the rest of files that you obtained? Would you perhaps note any similar notes such as this that is apparent on this particular one of Mr. Van Beek, as far as offences related?
My lord, I also Mr. J.H.H. Burger.
Just can place on record the full names of that particular.
His full name is, my lord, it is Johannes. Just get his name. Johannes Burger.
Johannes Hendrik Berger.
Johannes Hendrik Burger, ja. Yes, my lord. Johannes Hendrik Hannepom Burger, 3 names.
Is that the one officer that is going to testify behind the inquest?
That is correct, my lord.
Proceed.
In his file, my lord, page 1404, there is also a subs 96 extract from service record. And then, my lord, when you turn the page to 1405, it refers to a conduct sheet. En under that conduct sheet staan geskryf geen.
Also have file of certain Mr. Krenz. Able to shed light to the court if there's any such features that are apparent from this file.
My lord, I couldn't detect any SAPC 96 information with regards to Dirkotse genis. The only referral I take in his file is on page 768. And then it gives his loopbaan geskiedenis. But under that, there are no misconduct.
Council. As the court pleases, Lord, we do have a few follow-up questions for Colonel Peterson. Colonel Peterson, firstly, I must commend you for the very detailed and thorough investigation that you carried out. It does appear to us that you have left no stone unturned. The family is grateful for the hard work that you put in.
Thank you.
In your statement, you indicate that you were brought onto this investigation a little late in the day. In fact, only during August of 2020. And you also explained that your predecessors were Colonel Tobias, also Colonel Jonas, also the office of specific crimes. That's also the Cold Crimes Office, is that right?
No, my lord, it's not the Cold Crime Office, it's specific crimes. It does resort under the Deputy Provincial Commissioner Crime Detection. It is a component resorts under the Deputy Provincial Commissioner Crime Detection. At that time it was Major General Geary.
You'll have to turn on. Then you mentioned that at that time you received the 3 white Lever Arch files marked Weber Wenzel. We're not going to go through those files again. Can I ask you what you received from Colonels Tobias and Jonas? Is that perhaps mentioned in your paragraph 4?
My lord, these files was what I received from Jonas, Colonel Jonas, as it is. I can recall, I think, myself and Colonel Jonas at the States had a meeting with Ms. Odette Geldernis also, with that files.
Okay, the 3 white files.
Correct, yes, sir.
And did Colonels Tobias and Jonas give you an indication of what progress they had made with the investigation up to that point?
My lord, no, not in detail. By that I mean, it was a time when they were busy with their application of retirement, and that were mainly their focus. The few engagements we had, myself and Colonel Jonas, was with appointments we arranged. I think Mr. Khan and Mr. Muhammad also at the time were present when myself and Colonel Jonas consulted with them, and then we followed up information transpired out of that engagement, and we gave feedback to that effect as well, my lord.
So, as far as you were concerned, did you believe at that time that you were effectively starting the investigation fresh, from scratch?
Yeah, if I should say so, my lord.
Okay. So I'm just noting that approximately 8 months passed between the representations made in December and handing over the case to yourself. Of course, there were other big events happening at the time, not least the COVID pandemic, which I assume also had some impact on the investigations. If we could move to a question that His Lordship put to you about the changes to the different scenes, namely the police cell at Maitland Police Station, as well as the staircase at the Ben Caledon Police Station. And as I understood your evidence, both scenes were pretty much the same. And if I did hear you correctly, it was put to you that the sleeping bench, that concrete sleeping bench that is currently in Maitland Police Station cell was not there at the time of the Haron case. Is that correct?
Correct, my lord. That is what Mr. Burger told me at the time of pointing out.
Okay. And, my lord, there is in fact evidence in the first inquest that supports that. And that comes from Captain Malan, the then station commander at Maitland Police Station. And in volume A3, that's the English translation of the transcript, at page 36, lines 10 to 12, Captain Malan, I believe, confirms in a question put to him that the deceased was not lying on a concrete bench because there wasn't one. That's why, in fact, he was lying on the floor on a sleeping mat. Colonel Peterson, in your investigations, did you ever come to identify who the then investigating officer was who was appointed to investigate this matter following the death of Imam Haron back in September 1969?
No, my lord.
So I can tell you that we've also been searching to see if we can come up with a name, because presumably, following a death in police custody, typically an investigation officer would be appointed. Is that your experience?
Yes, my lord.
And we also know that in the inquest proceedings, there's no statement from an investigating officer, and no investigating officer was called to testify, which I suppose gives rise to the question, was there in fact an investigating officer at all? In your view, is it possible that in this particular case there was no investigating officer?
My lord, in this matter, I didn't pick up a investigating officer attached to this incident or the death of the Imam at Maitland cells.
Because typically one would expect the CID, detective branch, to become involved. And certainly in the other cases I've been involved in, Ahmed Timal, Neil Agat, Hussein Hafaji, CID investigating officers were appointed in each of those cases. Of course, they were a few years after this case. And sadly, we don't have the investigating docket or the inquest docket. It appears that you weren't able to recover. Am I right in saying?
I couldn't recover it. Correct, my lord.
Right. And if we had that, maybe we would have discovered whether there was in fact an investigating officer or not. And on that score, Colonel, would you be surprised to hear that the statements of the security branch officers were attested by other security branch officers? Does that sound proper or improper to you?
My lord, if I'm going to answer it in this way, if I'm giving a statement under oath, and then the member who's commissioning the statement, he must make sure that that statement, I've signed it in his presence. And that is what he will commission, that the statement was signed by the deponent in his presence, and he knows and understands the content of that affidavit submitted by such deponent.
Indeed, but the point I'm trying to make is that under normal circumstances, you would have the detective branch investigate, and the detective branch would take the statements. Not members of the branch who may very well prove to be suspects in the course of the investigation. So I suppose I'm putting it to you that we view the attesting of the statements by the security branch officers, by other security branch officers, as improper in the circumstances. Would you agree?
My Lord, I cannot comment on the working methodology followed by the branch, the safety and security branch then. But I can answer like this. If an incident like that should have happened now, the standby detective, the CID detective on standby would have been called out, attend to the crime scene. You would have arranged LCSC or photographers and photograph the crime scene, and then whatever exhibit sees or whatever that he will follow up, and then he or that detective will then conduct the investigation from attending the crime scene, if it was now. But I cannot comment, my Lord, with regards to the methodology, the working methodology that was followed then. I have no knowledge of that, my Lord.
I think, if I understand counsel correctly, he seems to suggest that the commissioning of the affidavit by a co-member in the same unit sounds somehow untoward.
Yeah.
Would you agree with him on that? I think that's the suggestion that he's trying to say. In lingua franca, there's something fishy about it. Whether it's snoop or hate, we don't know.
My Lord, I cannot comment on that. I'd rather not comment on that.
Thank you.
Well, let me put it another way, Colonel. Does it not give rise to a suspicion that the security branch officers who attested it may very well also have taken those statements? Wouldn't you have wanted somebody more independent, removed from the situation, for example, the CRD, to be taking those statements and attesting them?
Yes, definitely, my Lord. For objectiveness.
Thank you. Thank you. And because we, and we will provide a list of who attested which statement, we'll hand it up as an exhibit in due course. And the fact that no investigating officer testified as a statement of an investigating officer as an exhibit before the first inquest court, leaves the unfortunate impression that this particular investigation was largely kept in-house within the security branch. Would you also gain that impression?
That is the same impression I got, my Lord.
Moving on, Colonel, in paragraph 14 of your affidavit, your first affidavit.
Maybe before you get to that, just on the previous question, it also seems that actually fairness and funding, for all intents and purposes, were leading investigators, for lack of better terminology, of the Haron murder. And I'm saying this on the basis of, if you look at the record and the inquest, it doesn't appear that there is anyone else within the police, whether high above them or lower or equal in rank, who was involved with them. It seems to me that even after the death of the Imam, Van Wyk and Gienes were seized with that matter. And I'm following up on counsel's impression that it seems that this matter fell within the security branch. But for me, it seems to be more narrow. It is actually narrowed to basically the two officers. I mean, they are the ones, for instance, as I indicated previously, who go to the morgue. They are the ones who go and inform the family, it appears, about the death. They are the ones that are basically in charge of seeing to it that the post-mortem is done. You know, and if you look at their conduct and how Van Haron, I think it is, the public prosecutor, led them, in the absence of no other, it seems that they assumed the role of investigating the matter.
My Lord, I would agree to that because all information furnished or obtained came from them.
There is no other member of the police, including their superiors, including Pina.
Came from Genis and Van Wyk, Speaker.
I see. So for all intents and purposes, they are the ones who are pointed out and suspected by the left escorts, I call them, to have been responsible for the death of the Imam. But they are actually the ones also investigating or being in charge of that matter after the death of the Imam.
Correct me, Lord, they are the ones who's giving an explanation with regards to what happened at the staircase. And there's testimonies and statements given to that effect.
Thank you. You're welcome to proceed, Counsel.
As the court pleases. And just following up His Lordship's line of questions, we're aware that Genis and Van Wyk, once they were notified that Imam Haron had died in his cell, they proceeded directly to that cell and entered the cell. Am I correct in saying that typically when a detainee, or for that matter, any other person in the custody of the police are found to be dead in a particular place, for example, like a cell, would that cell first not be sealed off for forensic investigators to do their work first before allowing those, strictly speaking, not involved in the investigators, let alone the interrogators themselves? Is that not standard practice?
My Lord, correct, it is a crime scene and it needs to be cordoned off and treated with that respect.
And so typically what would happen, for example, if you were told, we've just discovered this man dead in his cell, what would be the typical steps that you would take arriving on that crime, that death scene or crime scene?
My Lord, what is important arriving on a scene like that is to ensure that the scene is secure, meaning cordoned off. If somebody had access to that scene, who was those persons or members maybe access or enters the crime scene, so that you can interrogate or interview them afterwards for their reasons, the purpose and whatsoever. Then as the body is, as far as possible, you keep it in that position. You activate the photographers to come and photograph the crime scene. They will do, and you ask them to maybe check for any DNA, any other exhibits which can be seized on that crime scene. After they finished what they supposed to do on the crime scene, then it is important that the person is certified as dead. Then you arrange for the forensics to come out to remove the body. And then, Your Worship, sorry my Lord, it is important the identification of the deceased, who the person is.
If I could just ask you to pause, we just go back to the forensic investigation. You mentioned photographs, you mentioned searching for possible DNA evidence, which I include traces of blood. Am I right in saying not only on the deceased, but elsewhere in the cell?
In the whole cell, the whole vicinity of the cell, we check for any evidence, any exhibits.
And perhaps fingerprinting to see who might have been in that cell?
That is part of what you're looking for, Your Worship. My Lord, and then
We'll Colonel, if I may follow up. Is there any evidence that any of that happened in this case?
I didn't detect that.
It seems to me, Lieutenant Colonel, that in fact there was never any industry by the crime investigating detectives of Maitland or any other detective in this matter.
Correct, my Lord. I didn't pick up any of such investigations.
It seems to me that, if I may use Robben Island as an example, being in Cape Town, that for all intents and purposes, the security branch was a Robben Island, far removed from the main South African police service, at least with regard to the death of the Imam. It seems to me that it was a don't touch. There was a sea in between.
My Lord, if I can respond to that, I asked Mr. Burger, Johannes Hendrik Burger, that same question, and then his answer was that the instruction to them was they must not interfere with the safety branch's detainees. Whatever happens, they must inform them first. That was the answer by Mr. Burger to me.
So the rest of the South African police service, at least in Maitland, was a no-go area for them.
Correct.
For the Imam. He was the subject of the security branch and no other.
That is what I understand from Mr. Burger, my Lord.
Thank you. Welcome to proceed, Counsel.
As a court reasons. So Colonel, there's no evidence that any of the basic post-death crime scene type investigations took place. And indeed, if it did happen, there would have been evidence of it in the first inquest. But what we do know is that both Hennis and Van Wyk were in the cell with the deceased. We also know that both security branch officers proceeded to the mortuary where they would have inspected the body and no doubt seen the injuries reflected on the body. We're trying to ascertain whether they were also present during the post-mortem, and once we've done our research, we will bring it to the attention of the court. But would you agree that the conduct of the two lead interrogators of a man who had just passed away, at least by today's standards, would have been regarded as, to put it mildly, improper?
I agree with that, my Lord.
All right, let's move to how it was that you got hold of a copy of the Haron Inquest.
Maybe before you
Yes,
the post-mortems, it seems to me that the Inquest Act today around this aspect still reads the way it read at that time.
In other words, there were certain amendments to the Act that came after what we're discussing. But there are certain provisions of the Act that appears to have been there at the time. One of them relates to the presence of a medical practitioner designated or instructed by persons with a substantial or peculiar interest in the issue relating to the inquest. But my reading of the record suggests that even if the Imam's relatives and acquaintances would have wished to have that, the manner in which the inquest was done excluded that participation.
I picked it up like that the family were excluded.
In fact, it seems to me that even the role and counsel speaks to the presence of Pennis or Van Dijk at the post-mortem. But the impression that I get is, unlike other inquests where there would be some custodian who identifies the body to the medical practitioners, in this instance, the body was pointed out by members of the security branch. If my recollection of the record is correct, that it was not a situation, and that is why I'm saying it seems to me that the security branch, in particular Hienes and Speiker, they were basically in charge even after the death, because one sees them at the post-mortem being the one that says to the doctors, here's the body, and it is the body of the Imam.
Yes, my lord.
You're welcome to proceed, counsel.
As the court pleases. My Lord, we will confirm, we are working on a very detailed chronology or timeline in which all these different events as they unfolded will be set out, and as soon as it's ready we will hand it up as an exhibit to your lordship. But we can confirm, for example, that Van Wyk, in his evidence, confirms that he saw the body on the 27th of September. We know that the post-mortem was done on the 28th of September, but I do recall reading, and we will find the reference for your lordship, that it was these two officers who confirmed the identity of the deceased to the medical practitioners carrying out the post-mortem. We will revert with that reference. Branch appeared to be keeping things quite in-house in order to keep more independent investigators at bay. Those are at least the submissions that we will be making in due course. Now, I do intend to return to the quality of the investigation a little later, just to clear up a few other matters. You mentioned in paragraph 14 that you received a digital copy of the inquest record, which you then had transcribed. And you said that you got this digital copy from the South African National Archives in Pretoria. So did they give it to you by email or perhaps in a memory stick?
On a memory stick, my lord.
I see. And then when you say transcribed, do you really mean you just printed all those documents?
Correct. All those were printed.
I want to also clear up one other issue. In paragraph 17, you looked into which of the remaining police officers were still alive. And you mentioned that of the police officers who directly or indirectly involved in the interrogation of Haron, only former Constable Johannes Hendrik van Berger was still alive. Correct me if I'm wrong, he was a constable based at Maitland Police Station, so I presume a uniform branch member. So I think we can safely say that he was not involved in the interrogation.
My lord, yes, he was attached to the uniform branch. His duties that time was that he was the cell guard. He had to open the cell doors. That's the only thing he needed to do. He had to open the cell doors, and then now and then he must see to it that the imam are receiving exercise within the inner plane there of the cells. And then he was also working outside attending to complaints.
Okay, unless there's evidence to the contrary, I think we can then accept that that was the extent of his involvement, and of course we will hear from him in due course. Let's turn to the question of the dates of death. And in your investigations, in your paragraph 18, you confirmed the deaths of those 4 individuals, Major Kotzer, Captain Geldenhuis, Captain Malan, and Sergeant Rademacher. And then subsequently you were able to confirm that Sergeant Spijker van Dijk himself passed away many years ago in 1990.
Correct, my lord.
Now, we've also been looking into deaths of individuals involved. And I think we concurred with the results of your investigations in relation to Rademacher, Pienaar, Malan, Geldenhuis, and Guinness. However, there is one individual who is not on your list, and that's Andries van Wyk, referred to in the record as Sergeant AJ van Wyk. And apparently Sergeant AJ van Wyk was the brother of Sergeant Spijker van Wyk. And Lord, there is reference to him in the record of the first inquest. It's in volume 3, that's the English translation, at page 6, lines 15 to 20. And there Major Guinness testifies that Sergeant AJ van Wyk also spoke to the deceased. And it appears that Sergeant AJ van Wyk may have been involved in speaking, or shall we say interrogating, the deceased between the 20th of May and 11th of August. And this would have taken place in Caledon Police Station, either in the cells of one of the officers. We know that on the 11th of August, deceased was transferred to a cell in Maitland Police Station. Now we haven't been able to confirm his date of death. We don't know for certain whether in fact he passed away or not. Did you have any occasion to look into Sergeant AJ van Wyk, Andries van Wyk?
Yes, my lord.
sent to the court. And how long do you anticipate to be busy with the witness?
I'm just checking as to whether, we should try to push the witness details today or whether we should reserve it for another day.
My Lord, my estimation is that we could probably complete our follow-up with the Colonel within about 15 minutes or so.
15 minutes from now. All right. Then perhaps we can go. But I'm not prepared to go later than 15:45.
Okay.
Remember, once we are in here, there's some admin work that my support staff needs to do. So it's only fair that we give them more time. Otherwise, they leave here at 7.
Totally understood, Your Lordship. I'll endeavour to wrap up in 15 minutes, and if we can't, I'm sure we will find a spot in the schedule to recall the Colonel. Which unfortunately can't be tomorrow because we have the inspection and another witness.
Yes.
Colonel, I'm under some time pressure now, so perhaps I can assist you.
Yes.
There is in fact a personal file dealing with Sergeant Andries van Wyk. Let me see if I can give you the reference for it. So the reference we have for it is that it's DDP 24, page 1485 of the NPA record. So we note, of course, that notwithstanding his involvement in questioning the deceased, he didn't make a statement, and nor did he testify in the first inquest. And we should draw your attention to at least one complaint that we found that was made against him. And Lord, that's the same reference, DDP 24, Roman numeral 6, at page 1542 of the record. And to be fair, this wasn't an incident that took place while he was a police officer, but it appears that in his application to join the South African police, he confirmed that he was convicted in the Vryheids Magistrates Court for an assault on, and I quote, a native, and he was fined £10. So we will be suggesting that Colonel Pino, you may want to look more closely at Sergeant Andries van Wyk, who may very well have a propensity to violence, giving his at least one conviction for assault. Is there anything specific you can say? Anything you can add to that, or should we move on?
I know, I also see page 1542.
So you also see that same conviction of assault?
Ja, it is hier aansoek om inskrywing.
I think we can move on, Colonel. If you do find anything of note, I'm sure you can bring it to the attention of your colleagues in the MPA, who will then bring it to the attention of the court.
Yeah, my lord, it's point 16 under that same form. Where it says, ja, verandering. Is u ooit, vraag 16 op dieselfde, on the same page, my lord, the question is u ooit weens 'n oortreding veroordeel? So ja, wat was die misdaad en watter straf is u opgelê? And then the answer, ja, vir aanranding, R10 boete.
Okay, thanks, Colonel. I think we can move on. That is essentially the same information that we also saw. Just as a matter of interest, his brother, Sergeant van Wyk, also known as Spyker, did you ever learn where this name Spyker came from? Which I understand is translated loosely into English as the nail.
Yeah, Spyker in English is nameless, my lord. But I couldn't detect as to why he was called Spyker.
So we are trying to look into it. We have come across a newspaper article which we will put up for your lordship to consider, in which an allegation was made against Spyker of driving metal nails under the fingers of a particular anti-apartheid activist, and it appears the name stuck. Of course, we only can view that article as an allegation and nothing more than that.
Do you have a comment on that?
No, my lord, no comments.
Right. So, Colonel, we must also thank you for taking the time to troll through the police files. That really is a lot of work, because altogether those files run into literally hundreds of pages. Perhaps we can bring to your attention one or two more matters. We noticed that in the file of Dirk Kotze Hennis, some years later he was found in possession of an AK-47, and he had no authorization or license for that weapon. That's at DDP 24, Roman numeral 1, between pages 896 and 899. As a matter of interest, we note that his file discloses that he was involved in the investigation into the assassination of Dr. H.F. Verwoerd in 1966. That's at page 768. We have also trolled through the Truth and Reconciliation report, and we note that there are some references to Colonel, at least to Major Hennis and others, but in order to save time, I think I'm going to put those up at a later stage, Your Lordship. I just want to see whether there's anything of note. Yes, in the police file of Johannes Petrus van Wyk, we were interested to see a confidential report dealing with his promotion. He was an individual who does not possess all the necessary qualities of leader, and that's at DDP 24, Roman numeral 8, page 1855. There's also quite substantial reference to Spijker van Wyk in the Truth Commission report, which we will return to later in these proceedings. So perhaps let me conclude by asking you to comment on the general quality of the investigations. We've already heard, Colonel, that there was this practice of security branch officers attesting, perhaps even taking statements of other security branch officers. We know that no photographs were taken at the autopsy. One can compare, for example, in the Timon inquest, where very detailed photographs of the body at the post-mortem were recorded. We only have one photograph of the death scene. There's no evidence that any attempt was made to bring Sergeant Andries van Wyk before the court, either by way of a statement or testimony, even though he might have extensively questioned the deceased over several days. And we've already heard in the exchanges with His Lordship that the death scene investigation was substandard. So, would you agree with me that this particular investigation was predisposed to a finding that the deceased had fallen downstairs, and that explains his ailments? That seemed to be the singular purpose of this investigation, if one can even call it an investigation.
My Lord, I will answer it like this. If I had received a docket like that and I suppose for outstanding investigation that still needs to be dealt with in a matter like this, then I would have requested, to complete the chain with regards to the deceased. That would be, by whom was he detained? That would be sales visits. Were the sales visits? The person in charge of the CSC, there should be entries made to that regard. Any complaints, was it recorded? That would have been part of my outstanding investigations, which I would have identified. Any complaints by the deceased, was it recorded? Is there OB entry? Who attended to that complaint? And then you request statements or 212 statements if it's a medical practitioner with regards to the purpose of his visit and the circumstances and all that. Then obviously, who's the last person visiting the deceased and the reason for the visit? Now I don't see, and then at the crime scene, was LCRC, the photographer, activated to attend to that crime scene? I don't see that type of investigation in this incident.
And just to follow up, if it wasn't for the probing questions and the insistence of Advocate Cooper SC to recall Captain Malam, the station commander, and to require him to bring the occurrence book to the inquest, that first inquest would have been none the wiser as to the extraction of the deceased away from his cell between 17th and 19th September. And dare I say, this inquest would have been none the wiser as well. So what's your comment on the withholding of that occurrence book or register from the first inquest?
My Lord, I don't know the reason why it wasn't available. But that are important information, as I have explained to the court now. Your occurrence book would give you a picture who visits. If there were complaints or incidents, it would have been recorded in that book. And then the cell register, the SCP-14, the deceased or the detainee's name, surname, would have been written in there. At the time of detention, the occurrence book will tell you who is the person detaining and the reason for detention. And if there are possibly instructions with it, it would have appeared in that occurrence register. The same with the pocketbooks of those members.
My Lord, I believe I've kept within the 15 minutes. No further questions for this meeting.
Thank you. Do you have any other example? None, my lord.
Thank you. Lieutenant Colonel, just one thing, the doctors who did the examinations of the deceased, to your knowledge, is any one of them still alive? No, you didn't follow that.
I did submit a letter to Home Affairs, but I didn't have ID numbers of the doctors, my lord.
Alright.
It's only names, so they couldn't assist me with names alone.
I see. So we don't know whether these doctors are still alive or not?
Yes, my lord, I cannot say.
I see. Thank you. Thank you for your assistance.
Thank you.
We will be taking an adjournment for tomorrow. Perhaps just to indicate that as we have agreed, we will be starting at 9:30 at the Cape Town Central Police Station. I just have to make the following plea, especially to members of the media. I want you to respect the privacy of the discussions. And I'm making this because we will be in an open space for the better part of the time, except for the narrow times that we'll be moving into the police station, the passage, and or the cell. But my plea to you is please respect the discussions between counsel and the families, or the discussions between counsel and the witnesses. They remain private, they remain privileged discussions. I do not want to sit with a situation where I lose friends with some of you by Wednesday because some things have been flighted, which is information that was not supposed to go public, which is privileged discussion between counsel and their clients. So I just want to reiterate that. Otherwise, as I've already indicated, the office of the OCJ media unit, Ms. Uli, you've already met her. She'll be in charge of attending to your issues and your plans. But I just thought I should just express that to you, to say, in as much as one is trying one's best to make this accessible to the public as it is, it should not compromise the sanctity of the fountain of justice from which the South African Police Service, the National Prosecuting Authority, and the Imam's family should drink. It shouldn't be poisoned, especially by the South African media. That would be my request. But otherwise, as I indicated, we meet at 9:30 tomorrow. Thank you.
Lord, I do have a suggestion.
Yes.
To your Lordship on that question. Perhaps during adjournments when counsel and clients and others do convene, your Lordship may consider suggesting to media present that the audio be turned off during adjournments, for example, tea breaks and lunchtime.
Yeah. I think that's a fair request. Please make sure that, as I said, the discussions between council and their clients is not meant for public consumption. Some of you are aware of that. Some of you have not given problems to that. But there are also some of you who are very naughty. All right. So please refrain from that. I expect the professionalism that I've always experienced with the South African media in matters that I have dealt with, which have gone on public record. It shouldn't be that we start today where we compromise proceedings of the courts. All right. Because if you go into that space, you cause me to regulate me, you.
His findings and conclusions based on his different calculations. And secondly, we have asked a former detainee, Mr. Yusuf Gabru, who was detained at the former Caledon police station and interrogated there and moved around, to have him on standby in case your lordship wishes to inquire from him how spaces looked in those days and perhaps where the detainees were moved around. So we do have Mr. Gabru on standby should your lordship need him.
Yeah, I think it will be helpful to state, as I indicated previously, to say it will be helpful to have all the witnesses who may be testifying about especially the two particular scenes to also be present during that, so that whenever we discuss those things in testimony, at least every one of us has got an idea of what we're talking about. I think that's the main purpose of us visiting, so that we can relate to the testimony. Look, for instance, with Mr. Mugi, I do not expect him to give his testimony there, but to indicate this is the scene, this is where I took the measurements, this is the rest of his testimony will take in court. Just to identify the scenes, have a sense of where the Imam was and what happened, those kinds of things. Yeah. So the witnesses that may shed light on that, or which the parties intend to lead in relation to the scenes, it will be better if what we are going to see is not covered by their testimony, that they also take us to where the evidence is anticipated to be led, so that we don't have to schedule another visit to see another place when we could have seen it on the visit tomorrow.
As the court pleases. On that score, my lord, perhaps our friends from the NPA can indicate whether Mr. Berger might be present at the visit to the Maitland police station cell.
The Maitland police station, yes. Council.
We will just discuss that further with the police officer. As far as we were informed, his appointment was attended to this week. However, we had been provisioned for him on Monday, which was the day that we intended to share his testimony. However, we nonetheless double check that as soon as we got the chance, then there is a possibility that maybe perhaps he might be available later.
Yeah. Look, even if he may not be personally present, if you have an idea of what his testimony relates to in the areas that will be applicable, I think it's better that the investigating officer will be there to take us through this area, so that we have an idea of what we're talking about. I think that's the main idea.
We do have the photo album.
Yes.
The respective seats and
Exactly.
pointing out.
Yes.
So we don't refer to those away of screen to do the indication as well as the interface for you to protect or whatever.
All right. Thank you. Anything further? That would be all. Thank you. The court adjourns.
Right. We need a manpower for the windows.